It's December. Wow. That was not right. I apologize for that. That was my fault. Let's start over, shall we? My name's Lone Wolf Usul. It's December 25th, 2025, and this, ladies and gentlemen, is the court gallery. Hi. And Merry Christmas, kids. Yeah. It's Christmas, and I'm confusing myself all over again. I thought I had everything set up, but you know how things go. I just am not ready for anything. But we're going to do this, and we're doing it an hour early. We're starting things off in Kansas, ladies and gentlemen. We're going to go with Judge Hart, Judge Lee, and Judge Ricky, and they all have some defendants who have desperate pleas to get out of jail for Christmas. Whether or not they deserve it or not, well, that's going to be kind of up to you to decide. Then we're going to go talk to Judge Stevens out in Texas, and he doesn't necessarily have any defendants who are making Christmas-related pleas or anything, but a lot of the conversation around these cases seems to center around the holidays, and it's a lot of fun. But when we get to Wisconsin with Judge Mogen, ladies and gentlemen, we're back in the saddle with people having holiday woes and pleas and everything else under the sun. And I just want to say, I couldn't leave Thurston County out of this. So when I noticed that Thurston County was having a Christmas Eve in custody calendar, I decided to go through it at last minute, and we have a nice, healthy helping of Thurston County from Christmas Eve to watch. Ladies and gentlemen, it's a 3-hour-long Christmas Eve special bonanza, and it all starts right now.
Cases are entitled State of Kansas versus Cody Hills, 20 CR 321 and 25 CR 238. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Mr. Hills, appears in person and by court-appointed counsel Joe Favre. This matter does regularly come back before the court this date on the pretrial conference plea docket. And announcements to the court, Mr. Favre.
Judge, I think we have both cases in front of the court today. We have reached a plea agreement that encompasses both cases. In 20 CR 321, Mr. Hills will be entering a plea to an amended Class B domestic battery. That is a plea of no contest. In 25 CR 238, Mr. Hills will be entering a plea of no contest to counts 1, 3, and 5 of the current information, which are aggravated domestic battery level 7, criminal restraint class A, and endangering a child class A. And then state will dismiss criminal threat counts 2 and 4. At sentencing, recommendations will be mid-box and follow presumption. We anticipate Mr. Hills will be presumptive probation in these matters.
And Ms. Norris, is that the state's understanding of the plea negotiations?
That is accurate, Your Honor. Thank you.
And Mr. Hills, Mr. Favre has advised the court you do wish to enter a plea of no contest in case number 20 CR 321 to amended count domestic battery, Class B misdemeanor, and you do wish to enter a plea of no contest to counts in case number 25 CR 238, counts 1, aggravated domestic battery, a level 7 person felony, count 3, criminal restraint, a Class A person misdemeanor, and count 5, endangering a child, a Class A person misdemeanor. Is all that correct?
You need to unmute yourself first, Cody.
I apologize. Yes, Your Honor.
Mr. Hills, there are a number of questions that I do need to ask you prior to the court accepting your plea herein to make sure that you're knowingly and voluntarily entering your plea. Sir, how old are you?
30 years old.
Are you married or single?
I'm single.
Are you employed?
Not at the moment, Your Honor.
What type of work have you done in the past?
My main trade is a cell tower technician. I also recently have been a machinist, a CNC machinist. However, I think I'm going back and hopefully once we can get this settled, I'm going to attempt to go back into cell towers and do that.
What is the highest level of education that you have obtained?
Trade school.
Have you graduated from high school?
Yes, Your Honor.
Are you making your plea voluntarily?
Yes, Your Honor.
Have there been any promises or threats made to you which have influenced you to plead no contest?
No, Your Honor.
I understand there have been certain plea negotiations entered into between your counsel and counsel for the state. Do you understand, even though the attorneys may make certain recommendations in regards to sentence, the decision in regards to appropriate sentence is mine pursuant to the sentencing guidelines for the state of Kansas?
Yes, Your Honor.
When you plead no contest, you surrender and waive certain legal rights you'd otherwise have if you chose to go to trial. Do you understand you have the right to a speedy trial where your guilt or innocence would be determined by a jury, or if you chose to waive a jury by a judge?
Yes, Your Honor.
Do you understand in such a trial you'd have the right to confront the witnesses against you and have them cross-examined by your attorney?
Yes, Your Honor.
Do you understand in such a trial you'd have the right to subpoena witnesses who may have information favorable to you and call them to testify in your behalf?
Yes, Your Honor.
Do you understand in such a trial it would be the burden of the state to prove your guilt beyond a reasonable doubt on each element of the charges against you before you could be found guilty?
Yes, Your Honor.
Do you understand the judge and the jury must presume you are innocent until the state proves otherwise, if ever, beyond a reasonable doubt?
Yes, Your Honor.
Do you understand if convicted at such a trial, you would have the right to ask the court for a new trial, and if denied, would have the right to appeal your conviction and your sentence to the appellate courts of the state of Kansas?
Yes, Your Honor.
Do you understand you're giving up each one of these rights if you plead no contest?
Yes, Your Honor.
Do you understand the sentences which may be imposed?
I do.
In regards to case number 20 CR 321, domestic battery, B misdemeanor, you could be sentenced up to 6 months in the county jail. In case number 25 CR 238, count 1, aggravated domestic battery, a level 7 person felony. He could be sentenced anywhere from 11 to 34 months in prison. If you would have a criminal history of one person and one non-person felony or less, there's a presumption you would be placed on probation. If you would have a criminal history of two-person felonies or more, there's a presumption you would be placed in prison. On count 3, criminal restraint, a Class A person misdemeanor, you could be sentenced up to 1 year in the county jail. And count 5, endangering a child, once again, a Class A person misdemeanor, you could be sentenced up to 1 year in the county jail. As you appear before the court today, I do not know what your criminal history is, if any. You would best know what your criminal history would be. Do you have any question as to the sentence the court may impose?
No, Your Honor.
Do you understand that in addition to the possible sentence and fine, the court will order payment of court costs? I may require you to pay restitution for any personal injury or property loss. I may impose administrative costs of the probation program and may require you to reimburse the state for your indigent legal fees.
Yes, Your Honor.
Have you ever been adjudged mentally ill by court?
No, Your Honor.
Ever had a guardianship or conservatorship set up to handle your affairs?
No, Your Honor.
Are you presently under the influence of any intoxicating liquors or drugs?
No, Your Honor.
Have you had plenty of time to discuss this case with your attorney?
Yes.
Would you like any more time to talk to Mr. Favre about the matters we've just discussed?
No, Your Honor.
Keeping in mind all matters we have discussed, is it still your wish to plead no contest?
Yes, Your Honor.
The court at this time will accept a factual basis from the state and Ms. Norris.
Your Honor, regarding 20 CR 321, Your Honor, on February 11th, 2020, in Augusta, Butler County, Kansas, the defendant did, in a rude, insulting, or angry manner, put his arm around the neck of the victim, Kennedy Bratton, basically putting her in a chokehold. And they were in a dating relationship, and I believe lived together at that time. Will that be sufficient for the court in the 2020 case?
Yes, it is.
And Your Honor, in 25 CR 238, on count 1, on May 25, 2025, also in Augusta, Butler County, Kansas, the defendant did place Nika Prohaska who he shares a child with, and they were formerly in a dating relationship, but at this time they were broken up, did choke her more than once by putting his hands around her throat, and did do this in a rude, insulting, or angry manner. And same date and location on count 3, the defendant did restrain Nika Prohaska from being able to leave her vehicle, and she repeatedly asked to be released or tried to get away from the defendant, and he refused to allow it. And Your Honor, same date and location, ELH, year of birth 2025, which is the child that they share together. Defendant was extremely intoxicated, did take the child from the mother, and refused to give the child back, but the child was present during this whole incident, and that did place the child in a situation where the child's life, body, or health might have been endangered. Will that be sufficient for the court in 25 CR 238 for factual basis, Your Honor?
Yes, it is, Ms. Norris. And Mr. Hills, do you know of any reason why the court should not accept your plea of no contest?
No, Your Honor.
And Mr. Favre?
I do not, Your Honor, no.
Mr. Hills, the court does find that you are alert and intelligent, that you understand the nature of the charges and appreciate the consequences of pleading no contest. I further find that you understand the rights you're giving up by pleading no contest. I do find the facts of the case sufficient to find you guilty in case number 20 CR 321 of domestic battery, and in case number 25 CR 238 of count 1, aggravated domestic battery, a level 7 person felony, count 3, criminal restraint, a class A person misdemeanor, and count 5, endangering a child, a class A person misdemeanor. I further find your decision to plead no contest is freely given, and that you have had the advice of a good attorney with whom you are well satisfied. Therefore, I do accept your plea of no contest, find you guilty as previously set forth on the record herein. The court does schedule, Mr. Hills, your cases for sentencing. That would be February 19, 2026. That's a Thursday at 1:30. February 19, 2026 at 1:30 for sentencing. Immediately after the hearing, Mr. Hills, I do order you to telephone court services. Their phone number is 316-322-4153 for purposes of scheduling pre-sentence investigation report interview. Once again, the court does order you immediately after this hearing to contact court services 316-322-4153. Court does continue you on the bond that you have previously posted. I do order you to stay in contact and communication with court services. Keep them advised all times. Keep in contact and communication with Mr. Favre and your bail bondsman. Keep them both advised all times for an address, telephone number, place of employment. Any other matters to come before the court? Ms. Norris?
No, Your Honor, thank you.
Mr. Favre?
Yes, Judge. We would like to address the issue of Mr. Hill's bond conditions at this point. Mr. Hills is currently on an ankle monitor GPS combination unit, and he's had no violations. He's had excellent behavior since this case has began. And as the court noted, he's trying to gain employment. The extra cost and of the ankle monitor and GPS scram unit has been prohibitive to him. So we ask that be released at this time, pending sentencing.
Thank you, Mr. Favre. State's position, Ms. Norris.
Your Honor, I believe that the GPS has already been removed, but the scram unit, I believe, is still on. I think the court allowed the GPS to be removed back in July. Your Honor, we would ask that the scram unit be maintained. Defendant was extremely intoxicated, especially for this 2025 incident. I do believe it's appropriate. I think most of these issues came from defendant's alcohol use, and I do believe that it's appropriate for him to be maintained on the scram unit, at least until sentencing and possibly into his probation.
Thank you, Ms. Norris. The court does, if not previously ordered, does order elimination of GPS, does retain the requirement of a scram unit until time of sentencing. Then the court would review the same at that point. Any other matters to come before the court? Court finding none. Court is in recess. And Mr. Hills, you do need to contact court services, schedule the pre-sentence investigation interview. Have a good day, Mr. Hills.
You too, Your Honor.
Judge, I think that actually, I misspoke earlier. There is one more. Mr. Breed is currently at the jail. I'd forgotten we hadn't taken that up yet.
Do I have the opportunity to have a defense over the scram bracelet? Do I have an option to speak on my behalf, or anybody on my behalf for that matter?
So the court's already heard that.
Well, did they hear my side? I mean, they heard the prosecution side, but did they hear my side of the story?
We
I mean,
we did explain that you haven't had any violations. The court heard that.
I
So I don't
haven't
know.
had any violations, and this is not going to, first of all, it's extremely uncomfortable. And second, it's going to interfere with my ability to find employment
Right.
in towers. And not to mention that line of work is probably going to do something to this equipment. I mean, it's high RF and it's extremely potent technology. So I'm almost certain it would probably scram the scram technology. I've been on this for 7 months now. I have no desire to drink. I have no desire to do drugs. I have no desire to do any of that.
Excuse
I'm
me,
asking
the court, Mr. Hills, the court will go back on the record in your two cases. Cases are entitled State of Kansas versus Cody Lane Hills, 20 CR 321 and 25 CR 238. And the court, it has been brought to the court's attention that Mr. Hills does wish to address the court in regards to the scram requirement. And the court will listen to Mr. Hills at this time.
Thank you, Your Honor.
Please proceed.
Okay, so I've been on this bracelet for 7 months, and I totally understand why you guys have placed me on the bracelet. But I have no desire to drink. I have no desire to do drugs. It is all in my desire to do what is best for my son in this situation, and I'm trying to make the best of it right now. Not to mention it's extremely expensive, and I still owe on this. And it seems like the bill is just continuing to rise. It's extremely uncomfortable. Not to mention, even if I was to wear it at work, it would be extremely uncomfortable to wear in the climbing boots that I have to wear. But I'm just begging the court to just hear me on this issue. There's no desire that I have to drink or to do drugs or anything of that matter. I'm just trying to do what's best for my son at this point.
Thank you, Mr. Hills. Any further input from the state? Ms. Norris?
Your Honor, state would just rely on previous argument. We do believe that it's appropriate that he maintain it. And Your Honor, there are alternatives to the bracelet, but that still monitor his alcohol intake. And we would ask the court leave for, if he for some reason does get a job where that technology is not conducive to the employment, that the electronic monitoring people can make alterations with another format. But at this point, obviously, he doesn't have the job, so I think it's moot right now. But we would ask that the court maintain him on the scram device.
Thank you, Ms. Norris. Further, Mr. Favre?
Judge, I think everything Mr. Hill said is accurate. I've had a lot of discussion. We've had a lot of conversation over the last 7 months, and Ms. Norris would acknowledge that there's been no reports of him violating the scram unit. We would have been made aware of that. So, I mean, 7 months is a long time to prove you're sober. I think that we could give him a chance, and he is trying very hard to resolve these matters so he can resolve his current custody case, because he and Miss Prohaska share a child, and it's a young child, and so they're trying to figure out what to do with that, and that is his focus. I can say that's genuine.
Thank you, Mr. Favre. And Mr. Hills, the court does reconsider previous order of the court. The court does eliminate the scram requirement. The court does eliminate the scram requirement. However, I do order that you report weekly. I order you to report weekly to court services in regards to your current status. Court orders you to report weekly to court services until time of sentencing. The court does find there have been no violations of the GPS or the scram monitors. The court will give you the opportunity to prove yourself out in regards to your trustworthiness, continuing until the time of sentencing on Thursday, February 19, 2026 at 1:30. Once again, the court does order the elimination of the scram requirement as a condition of your bond, and the court does order you to report weekly to court services in regards to your bond modification of your bond condition. And Mr. Hills, do you have any question about that?
Is that in person? Is that going to be an in-person meeting?
Where do you live?
Right now I'm living in Winfield.
The court allows until sentencing on February 19, 2026, the court allows you to report by Zoom process if that is agreeable to your court service officer. I believe they have the capability to process that. You may appear by Zoom to your court service officer or in person if they do not have that capability.
There you are.
Any question about that?
No, Your Honor.
Okay. There being nothing further to come before the court is in recess. And what now at this, anything further, Mr. Hills?
No, Your Honor.
Okay. Court is in recess. You're free to go. Have
Thank
a good
you,
day.
Your Honor.
You do need to contact court services at this time.
Yes, Your Honor. Thank you.
Yes.
In the matter, State of Kansas versus Jordan French, there appears to be, I believe, 3 cases. Yes, case numbers 24 TR 1588, 24 TR 2095, and 24 TR 2131. If counsel would state their appearances, please.
Jared McGee on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Jordan French. Ms. French does appear from the video from the Butler County Detention Facility. Judge, we do have a resolution pursuant to plea negotiations to present to the court. I would announce at this time that Ms. French, in case 24 TR 1588, will plead guilty to the sole charge of no valid driver's license. And in case 24 TR 2131, she will enter plea of guilty to driving while suspended, Class B, non-person misdemeanor, and to speeding 98 to 75. State has agreed to dismiss 24 TR 2095. Judge, at the time of sentencing, there are agreed recommendations. First of all, in the 1588 case, it would be agreed to recommend a $100 fine, court costs for the court to determine attorney fees, a 120-day controlling sentence. In 24 TR 2131, on the driving while suspended, there'd be a recommendation for a $100 fine, court costs for the court to determine attorney fees, a 120-day controlling sentence, and on the speeding, the scheduled fine. The defense will be asking the court to grant a 6-month non-reporting probation, and the state is going to request a reporting probation.
Mr. Regier, is that your understanding of the agreement?
It is, Your Honor. The state does intend to present the court with argument for reporting probation at the appropriate time. In the 24 TR 2131 case, count 1 does appear to be charged as no valid driver's license pursuant to KSA 8235, not driving while suspended under KSA 82622, but the state's understanding is counsel's prior recitation of the plea negotiations in this matter is accurate.
And I stand corrected, and she would so plead to no valid driver's license in that case.
Okay, and that was 1588, or no, that was 24 TR 2131.
That is the state's understanding, Your Honor.
Okay, so yeah, 24 TR 1588 is a no DL. There was two of the cases had, but the case that is being dismissed was also an operate with no DL. Okay. All right, Ms. French, have you heard what the attorneys have told me?
Yes.
All right. You understand, and is that correct? That's how you wish to proceed by pleading guilty in two of these cases to the no driver's license
Yes.
in one case, and driving while suspended, a B misdemeanor, which should be a first offense for driving while suspended, and then 98 and a 75.
Yes.
Do you understand that while the court certainly considers the recommendations of the parties, the court is not bound to follow those? You could be on a B misdemeanor. You could have a sentence up to 6 months in the county jail and a fine not to exceed $1,000.
Okay.
And also on that, because there's two cases, the court has the discretion to order those be served at the same time, which is called concurrent, or consecutively, which is back to back. You understand those things?
Okay.
Oh, well, you
Yes,
understand
yes.
them? All right. Have you had sufficient time to discuss this with Mr. Patterson?
Yes.
And do you understand that with a plea of guilty, you'd be waiving your right to a trial?
Yes.
And that's how you wish to proceed?
Yes.
Okay. Ms. French, how old are you? 20?
Yes, I'm 20.
Okay. How far in school did you go?
To high school diploma.
Okay.
And is this the time like I get to talk or no?
No, not just yet. Here in a moment, I will. Has anybody forced or coerced you in some fashion, basically making you enter these pleas against your will?
No.
Very well. In regards to 24 TR 1588, were you operating a motor vehicle on a public roadway on June the 13th of 2024 when you didn't possess a valid driver's license?
Yes.
And in 24 TR 2131, that on or about August the 11th of 24, you operated a motor vehicle while you were suspended?
And Your Honor,
Yes.
forgive me, as previously indicated on the record, there is an amended information in that case alleging count one is no valid driver's license under KSA 8235.
Okay. So that would be operating a motor vehicle without a valid license.
Okay.
And
Yes, Judge.
speeding 98 and 75.
Okay.
Yes.
Okay. Did you do those things in Butler County on or about that date?
Yes.
I find that the plea is knowingly and voluntarily entered with the advice of good counsel. I do accept her plea of guilty in both those cases. Again, 24 TR 2131 being the no driver's license, without a valid driver's license, and also 98 and 75, and the 24 TR 1588 case, which is one count of driving without a valid license. So I do find her guilty in both of those. The 24 TR 2095 is dismissed with prejudice pursuant to the agreement. I will hear recommendations for sentencing at this time, beginning with the state.
Your Honor, with respect to count one in the 24 TR 1588 case pursuant to plea negotiations, the state would be recommending a $100 fine, that the court determine appropriate court costs and attorney fees, and impose an underlying sentence of 120 days. With respect to count one in 24 TR 2131, the state would also be recommending a $100 fine, that the court determine the court costs and appropriate attorney fees, and impose an underlying sentence of 120 days. The state has no objection to the court imposing the scheduled fine with respect to count 2 in that matter, the speeding. On the issue of probation, the state is seeking a reporting probation of 12 months, subject to all standard conditions, including a $6 probation fee in both cases. However, the state is not opposed to the court running these cases concurrent. Notwithstanding the plea agreement in these matters, these are cases, this is a defendant who successfully where it is alleged that these 3 cases occurred within approximately 2 months of each other, June 13th of 2024, August 11th of 2024, and August 9th of 2024. Additionally, it is the state's information that there is another case in Johnson County District Court involving the same defendant, Johnson County 25 CR 2480. It would appear that matter proceeded to disposition on or about September 30th of this year. In that case, it would appear the defendant was convicted of child endangerment and fleeing or eluding an officer with a date of offense for both of those of June 24th of 2025, while both these cases were pending. In that matter, pursuant to that same journal entry, it would appear that the court did order 12 months probation with court services, and the state does make the same recommendation in this case.
Thank you, Mr. Patterson.
Judge, we're asking the court to adopt the recommendations in all manner except the probation. We're asking the court to order a non-reporting probation. The reason we are asking for that, Judge, is she does not live in this area. She lives in the city of Wyandotte, up in northeast Kansas. She is employed at Aldi's in Lenexa. And as Mr. Regier stated, she is on probation in northeast Kansas, up in the Kansas City area. Judge, we had just asked the court to allow her to return on a non-reporting probation to the Kansas City area and abide by the conditions of that probation. She has a lot going on, and Judge, I would be fearful that if we end up with 2 probation officers, I don't want to set her up for failure, Judge. I just want to see her be successful, and that would be hopefully the probation up there in Kansas City area. Nothing further.
All right. Is she when was she brought to Butler County, and how much jail credit do counsel believe she'll be entitled to between these cases?
Judge, she was placed in the Butler County Jail December 9.
Counsel, I do not have the scheduled fines before me at this time. Do you have something that indicates the scheduled fine for 98 and the 75?
Your Honor, if I could have 1 moment of the court's time.
Yes. I will come back to that for an answer. I'm right while you're looking. I'm going to Ms. French. Is there anything that you'd like to tell me before I pronounce sentence?
Yes, I just want to say that I understand that I'm wrong, and I really learned from my mistakes being here. I have a 2-year-old baby. I've never been away from him for this long. I take care of him by myself, financially, physically, everything by myself. And my mom has been calling off work from the time that I've been in here. And Your Honor, I really miss my son. I don't want to lose my job. And I've been doing probation. Like I've never dropped dirty. I don't do drugs. I don't do anything else. And I've talked with my mom and my grandparents, and they're going to help me drive to every probation for here if I get it.
Well, what's this job that you indicate you've got?
Aldi's.
And how long have you been working there?
For about 6 months.
Well, Ms. French, part of my concern is you don't show up for court. You had 3 separate cases here, and it's not just once.
Yeah, I understand that, sir, and it's because like I told the judge last time that I had transportation issues, but I've been talking with my grandma and my mom the whole time that I've been here, and they're willing to help me
Ms.
with
French,
everything.
you say you had transportation issues, but you were caught driving without a license in some of these when you'd already failed to appear. So it wasn't,
Well,
you were still driving.
well, yeah, but I'm saying like for my own, like I didn't have no transportation of my own, is what I mean.
And you say your child is 2.
Yes, my baby is 2.
Okay, well, these are all within 2 years you did these things. So you
Yeah,
had a child then.
I know, and I understand that, and I'm learning my mistakes. I haven't been doing anything else since I've been put on probation. I don't want to keep doing this.
When were you placed on probation again, please?
In like August or September of this year, I think, or September or August. I'm not sure which one.
All right. How do you think you're going to be able to get these things paid off? If I follow the recommendations, you're going to have, I haven't added it all up, but it looks like certainly over $500, maybe closer to 1,000. How are you going to get those paid off in a 6-month period?
My dad and grandma can help me. He told me today that he's going to be able to put $300 towards my fines. My dad can. My family helps me out a lot. Because I work part-time because my son's dad is not in his life, so I have to take care of him.
Anything else before I pronounce sentence? Very well.
Your Honor,
Yes.
in response to the court's inquiry, the state's understanding is that the scheduled fine pursuant to KSA 82118 in this matter is $132. Also, it would appear that this is a defendant who has yet another case currently pending in another jurisdiction.
Okay, something other than the one that she's on probation for?
That is the state's information, Your Honor.
What county is that in?
Johnson County by the state's information, Your Honor.
Does it reflect the nature of those charges and when?
Your Honor, the state's information is that on December 1st, 2025, a complaint was filed in Johnson County District Court. It appears to allege one count of organized retail crime, a level 6 non-person felony. The state is not aware of a sentencing journal entry in that matter at this time.
You said organized retail crime?
That is what that's what the complaint appears to reflect, Your Honor.
I've been doing this for 40 years. I don't remember that charge. I don't think that and treason, I don't think I've ever had those charges before. But Mr. Patterson, do you have any additional matters or thing you'd like the court to be aware of? Or do you contest the 132 as the scheduled fine?
Nothing further, Judge.
All right. In regards to 24 TR 1588, I will impose a fine of $100. I will also impose a sentence of 120 days.
I'm gonna do
You'll
it
get,
my baby's birthday.
I'm not done, ma'am. I'm
Sorry.
not done. I will give her jail credit from December 9th of 25. If she has additional days for jail credit when she may have been in custody on other occasions where she was awaiting to see a judge and then was given another bond. I can't tell that from the notes right now, but she would also be entitled to those any day prior days than that December 9th on those cases. I'm going to order that be consecutive to the Wyandotte County case. In regards to 24 TR 2131, on count one, the driving without a valid license, I will impose a fine of $100, court costs and attorney's fees. I'm going to order that the attorney's fees, well, basically one attorney's fee for both cases. So 250 there. I'm going to impose this scheduled fine of $132 for 98 and 75. I'm going to I'm imposing the jail sentence of 120 days in that case as well. I will run those concurrent with the Butler County case, but consecutive to the Wyandotte County case. Ms. French, as I indicated, I got a bit of a dilemma, in believing that you're going to do well and report as directed.
Your Honor.
Please.
I'm sorry.
Don't interrupt. There's so many of these fatal to appears, and some of these, and then you just go out and do the exact same thing weeks or months later. So you're saying that you learned your lesson, but you keep making the same mistakes. Now, I'll let you speak if you want to say something else.
I was just going to say that I've learned my lesson because I've never been in jail this long. I've never been away from my son. And now I realize everything that I was taking for granted. And
all right.
I'm really sorry.
Well, is your son still in your custody?
Yes, he's been in my custody since he was born. He's never been with anybody else. If he's not with me, he's with my mom if I'm working.
Well, the nature of the type of charges from Wyandotte, often a child may be removed. That's why I'm asking.
Yeah, no, he's been in my custody ever since he was born.
I don't know that really makes me feel any more comfortable with you failing to show up, and 98 and a 75. I know it's speeding. I know it's an infraction, but good lands. How fast do you really need to be going?
Well, at that point, I had just got a new car and I've been driving a 2005 my whole life. So it just felt different to drive. Like I didn't realize that I was going that fast. And I told that officer too, when he pulled me over, I wasn't meaning to speed like that. Your Honor, please, I don't want to miss out on everything.
I've heard you out. Okay. Now, Ms. French, I'm going to place you on reporting probation from these cases. I'm making.
Thank you. I promise I will be here for everything.
Okay, ma'am, if you are going to keep interrupting me, then I'm going to set this case off for another day and do it again. So if you want to sit in jail, keep interrupting me. I'm placing, I've ordered that these cases, the Butler County cases, be concurrent with each other. So you owe Butler County 120 days. I'm placing you on supervised probation. I am going to authorize your transfer to your home county, if that is where you're reporting to a probation officer, if they will accept it. They are not required to on a misdemeanor. However, I'm going to place you on probation for a period of 1 year. If you're driving a new car, I think you've got the means to pay for things. I'm going to order all of these things be paid within 9 months. I want you to be making regular monthly payments. Now I'm going to tell you something else. You've several no-shows. You don't show up for probation. You don't follow the terms of your probation. Don't be asking me to put you back on probation if you get picked up again. Because my position on these things is you're an adult. You know what the consequences are. Now you've had a taste of what county jail is like to the tune of about 10 days. If you don't like it, then you know how to avoid it. You know, I would thought that would have been very obvious when you got arrested on other occasions and before the court. So I'm not really sure. I really don't buy this situation, but I'm going to give you a chance. But this is consecutive to your Wyandotte County case. So if they make you serve a sentence up there on something else, you know, that's not going to help you on this. So I would really be careful if I were you in regards to what you need to do. Your driving privileges, if they haven't already been, they're probably going to get suspended. Even if you don't have a license, they'll generate a license and suspend it. And part of your probation is no law violations. Now, I don't know how your Johnson County case is going to, if you're convicted there, that's not a violation. I'm taking that into account now because I'm aware of it. But if you get something else that, and convicted, that will be a violation of your probation. This will be a standard terms of the probation that's here. And if it's transferred, it'll be a standard conditions, whatever conditions you have where they're accepting you. So you have to comply with Butler County. If this is transferred to Wyandotte County, you need to follow their terms of probation as well, which are probably going to be largely the same, if not exactly the same. But the quickest way you're going to find out that you're violating is if you don't show up to meet with your probation officer. I'm going to order that. Is there still a hold on her?
Judge, I was just looking at that. I believe there is a hold on her.
Okay. I'm going to direct that court services contact you following this hearing. It may not be today, but get you signed up while you're here. But I'll authorize, this will be completing this case for now, so you can be released to that hold in Johnson County. So they'll either come and get you or they will change your bond conditions or something. But so court services, if it's possible, Mr. Bauer, to have somebody contact her yet today, that would be preferable, because I don't know, if they'll pick her up over the weekend or not.
Yes, Your Honor. I'll see what we can do. If somebody can maybe reach out to them or something, I'll see what we can get done.
But
I'm not sure who all we have available to work on that, but I'll see what we can do.
Ms. French, in the event that you are taken to Johnson County before you get signed up for probation here, you need to be contacting court services, giving them your information, and if they direct you to come here to get signed up and so forth, they'll make arrangements with you. You need to be sure you do that. There's several things you're going to have to take care of. Now, again, I've given you the warning I give others, but I'm not going to put up with it. And particularly with this history of not showing up for court. You don't show up and you know what the consequences are, and you still got 110 days or so to serve on this. So, you're going to get the opportunity you're requesting, but it's going to be your obligation. Be sure you comply. Okay.
Okay.
Counsel, anything further?
Your Honor, is the court making any orders on the issue of court costs in the 1588 case?
Court costs are assessed in both cases. Those are separate cases, and there's a separate court cost on each.
Thank you, Your Honor.
The attorney's fees will be one set of attorney's fees.
Very good, Your Honor.
I believe that's $250. There would be one probation fee. All right. Anything further, Mr. Patterson?
No, Your Honor.
Okay. Thank you. With that, the French matters are adjourned. Good luck, Ms. French.
Thank you.
Okay. Is this Jonathan Mays?
Yes, Your Honor.
All right. It's the state of Kansas versus Jonathan Mays, 25 CR 179. Counsel state their appearances, please.
Jared Reed here on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Jonathan Mays. Mr. Mays does appear from the Butler County Detention Facility. Judge, this is a case where we have reached plea negotiations with the state. Would announce at this time, pursuant to those plea negotiations, Mr. Mays will be entering a plea of guilty to the charges in case number 25 CR 179, which is count 1, possession of marijuana after prior conviction of possession of marijuana, class A non-person misdemeanor. Count 2, possession of drug paraphernalia, class B non-person misdemeanor. In return, the state has agreed to dismiss 25 TR 187. At the time of sentencing, Your Honor, the agreed recommendations in the 179 case is a $200 fine on count 1, court costs for the court to determine attorney fees, that there be a probation fee, a 6-month controlling sentence, and a 1-year reporting probation, and that he obtain a drug and alcohol evaluation and follow, or in the alternative, if he's had treatment, which he told me he has recently, that he provide all those documents to probation office to determine if they believe that is sufficient. On count 2, Jared, we didn't put anything down for that, so I'm assuming it's another 6-month sentence concurrent and no fine. Is that correct?
Your Honor, the state has no objection to proceeding in that fashion. Also, I do not know if counsel and my office had the chance to discuss this previously, but it is the state's information that KBI restitution does apply in this matter.
Does or does not?
It does, Your Honor.
It does, Your Honor, so acknowledged.
Okay. Very well. Mr. Mays, have you heard what the attorneys have told me?
Yes, I have, Your Honor.
And is that correct? You're changing your plea in case number 25 CR 179 to guilty to possession of marijuana after a prior conviction and a misdemeanor, and also to count 2, possession of drug paraphernalia, a class B misdemeanor?
Yes, Your Honor.
Do you understand that while there are recommendations made by the attorneys, the court is not bound to those? A person on an A misdemeanor can be sentenced up to a year in the county jail and a fine of not to exceed $2,500.
Yes, Your Honor.
And a B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. And that could be ordered to be consecutive if the court chooses to do that. You understand that?
Yes, Your Honor.
You understand that with a plea of guilty, you'd be waiving your right to trial?
Yes, Your Honor.
Has anybody forced or coerced you in some fashion to enter this plea?
No, Your Honor.
Are you under the influence of any medications or intoxicants at this time? Anything that makes it difficult for you to think clearly?
No, Your Honor. I've actually got September 4th as my sobriety date now.
Very well. And Mr. Mays, on or about April the 15th of 2025, did you possess marijuana having had one prior conviction for possession of marijuana in Butler County, Kansas?
Yes, Your Honor.
And did you have drug paraphernalia to either contain the marijuana or to help you introduce the drug into a human body?
Yes, Your Honor.
I find that the plea is knowingly and voluntarily entered with the advice of good counsel. There's a factual basis for the defendant's plea. Do find him guilty of those offenses. And I will hear if there's any additional recommendations in regards to sentence at this time. Mr. Regier?
Nothing further from the state, Your Honor.
Mr. Patterson?
Judge, the only thing additional would be that my client does reside in Wichita, that he is employed or was employed at Super Car Guys, West Wichita, that he has custody of a 17-year-old son, and he is asking the court to grant probation, allowed to be transferred to Sedgwick County if they can do that. Thank you.
Thank you. Mr. Mays, is there any statements you'd like to make before I pronounce sentence?
I'd just like to apologize to the court for wasting any time that I have in the past, for not showing up or anything of that nature. And also let you know, I have already done drug and alcohol treatment, and I'm trying to get myself on a better path and teach my son some things also about doing the right thing now. So just apologize to you guys for any time I have wasted of yours.
Looks like your prior conviction was out of Morris County on or about July the 7th of 2022. Does that sound right?
Yes, it does, Your Honor.
Mr. Mays, what I'm looking at are the notes, and I'm trying to count up all your failure to appears. And it looks like there's a minimum of 4 different days. You want to explain that?
The only way I can really explain it is I was still on drugs. I've since went to treatment, since gotten myself clean. I was making a lot of mistakes. I wasn't taking care of any of my personal business that I needed to be taken care of. And I want a chance to be accountable and to show everybody that I really am changing.
All right. It looks like in an earlier hearing, you indicated you had missed a hearing because you were in jail in Lyon County. That's different than Morris County and Sedgwick County, your home county. What'd you have out of there?
But I had a DUI.
Have you been to treatment before, sir?
I had in the past, yes. This is the first time that I've ever actually truly believed that marijuana was a problem. I'd always made excuses for it being different or a lot of other things, but
well, I was going to ask you that because I have some people that I refer to as the true believers that basically are just bound and determined that they're going to smoke or use marijuana in some fashion and want to argue legalities and so forth. Is that you?
that used to be me. Yes, Your Honor. It's no longer me. I know I can't do it because it causes other issues for me as well.
Counsel, how much time do you think he's entitled to on this case?
Judge, the jail record does show that he went into Butler County Jail December 11.
And Your Honor, the state's information is that your first appearance hearing was conducted on the subsequent day before District Judge Crum.
Mr. Mays, part of what gives me pause here is you said your sobriety date was September 4th?
Yeah, that's whenever I went into drug and alcohol treatment.
Well, you didn't show up on October the 20th as one of your failed to appear days.
Yeah. I was living in Sedgwick County and didn't have means to get over here at that point in time. My grandpa had been in and out of hospice and then wound up actually passing on November 12th and funerals and everything. And I'd called over and tried talking to Connie Mann in the district office and to see what I could do about getting things taken care of. And yeah.
Anything else you want to tell me before I pronounce sentence?
No, Your Honor.
All right. In regards to count one, possession of marijuana, I'm going to impose a 6-month sentence. I'm going to order a $200 fine. I'm going to assess a KBI lab fee of $400 and court costs. I'm assessing attorney's fees as well. I believe those are $250. I'm contemplating whether to place you on probation or not. In regards to count 2, I'm going to order a 6-month concurrent sentence with count 1. And I'm not going to impose a fine, as I did that. Basically, these were same date and largely the same offense, not legally the same, but certainly you rarely see one without the other. So Mr. Mays, I just don't know that you're going to, how serious you are in regards to complying in light of all these failure to appears and, not having a way of getting here. I just have a hard time believing that.
I'll actually be relocating to El Dorado because I'm going to be getting into the second chance house here. So
how are you going to be employed in Wichita if you're living here?
I'll wind up getting employment here. Like, I'm currently employed there, but I don't know if that employment's going to still be intact or not. So I'll stay over there until I need to, but I need to get over here. This is where my son's at. And he's just starting first high school basketball games, and I got to get things taken care of back with him also. His mom passed away 9 years ago, and that's really whenever I started to have things start going. I had 5 years of sobriety prior to her passing, and then whenever she passed, I started letting things fall apart again. And now that I'm realizing everything that's going on, I understand that I've got to be there for my son. I'm his only living parent. Yesterday was his birthday. Everything's just really hitting a lot harder right now.
You say he's here anyway. Obviously you haven't been then. Who does he reside with?
He's with my aunt and uncle. They're helping out.
Do they have custody of him, or do you?
No, I still have custody.
Okay, Mr. Mays, as you might be able to tell, I'm somewhat pessimistic in regards to.
I understand my history. Yeah, I'm sorry.
You seem to be candid and at this time, but I've seen that before with individuals, and you've got a lot of things that you've had opportunities. I'm going to follow the recommendations and place you on probation for 1 year. I'm going to order that you be making regular monthly payments. That court services will work with you in regards to setting up a payment plan. I want you to have everything paid for, though, within 11 months.
Okay.
You pay it off earlier and otherwise in good standing on probation, then I will allow you to, I will consider ending probation early if you are, again, if you are compliant with your probation and have everything paid off once you've served at least 6 months on probation. That, as I indicated, is a reporting probation. There is a cost with that. I believe it's $60. That'll be added to your costs as well. Okay, Mr. Mays, my belief on these things is you're an adult. You certainly, as much as anyone I've dealt with, know the consequences. Been through this. You've had violations. Part of your probation is you must remain clean of illegal drugs, and I mean Kansas illegal drugs. You are to have the standard conditions of a Butler County misdemeanor probation, no law violations. You are not to leave the state of Kansas without prior written authority. And if they do give you authority and you come back dirty, I don't want to hear that I was in Oklahoma and used, or Missouri, or wherever else. You're not to be using as a condition of your probation here.
And for my mental health, I can't. I'm sorry.
That includes alcohol as well. You appear to have addiction issues. You are to, when was the last time you had a alcohol and drug evaluation?
Would have been August, I believe. Yeah, it was right before I went to treatment.
Okay. And when did you get released from treatment?
Would have been the October 2nd, I believe, was the date that I went into College Hill, Oxford House.
Okay. I'm going to give the probation officer discretion to test you in regards to UAs for and if they have the ability to do hair follicles, I'll authorize that as well at their, as they see as being reasonable. But somebody with your history, I'm going to order that you take a UA. I'm placing you on probation. It's December. You say September was your last date of not being sober. I'm taking it then that you used on or about September 3rd.
Yeah.
That'd be the last.
Yes, sir.
My understanding on hair follicles is, generally 90 days. I don't know that probation does that hair follicle, but you should, while marijuana takes a while to work its way out of the system, I'm going to order that they do a test of you no later than February of 2025. If they're doing that test then and you're dirty, I expect them to be sending a violation. You shouldn't have anything in your system by then.
No, there won't be.
It should be worked out probably pretty close to now, actually, but February should be plenty of time. So that'll hopefully give you a little bit more incentive, but my belief is if you violate, then you're just telling me you don't want to comply and you'd rather do your 6 months in jail. So you know what you're looking at in the event that you choose to violate. Okay. Anything further, counsel?
Your Honor, what is the length of the reporting probation? Is the court?
I've set it at 1 year.
And is the court ordering a drug and alcohol evaluation in this?
I'm going to give him discretion in regards to that. If he had one in, you say August?
Yes, Your Honor.
That should still be valid. I want you to follow the recommendations of that evaluation. If I'm going to give discretion to the probation if they feel you need another one or an updated one to do that, and that'll be at your expense as well. Mr. Mays, if you're serious in what you've told me here today, there's programs here in Butler County and certainly in Sedgwick County that'll help you with your addiction issues.
Yes, sir.
So no excuses, okay?
Yes, Your Honor.
All right. Anything further, counsel?
And Your Honor, is the court finding that the other case is dismissed pursuant to plea negotiations?
Yes, dismissed with prejudice.
And Judge, I would just ask the deputy to write down a phone number for him. That would be a phone number for probation, and that is 316-322-4370. Although he may get out there before 5, I'm just thinking probably not.
Well, and I will permit him to be processed out at the Butler County Jail. Mr. Mays, do you have somebody that you can contact to get you picked up?
Yes, Your Honor.
All right. Looking at your other case, do you have a valid driver's license at this juncture?
No, I do not, Your Honor. I just have Kansas ID.
Okay, well,
I've got to get
be
it.
the standard conditions of probation, which includes no law violations. So
Yes.
I don't
And
know.
I'm not driving unless I have a license.
Selling cars, I would think would be pretty difficult without driving, but
I'm in the call center. I'm not actually out selling the cars. I get paid hourly plus commission.
I see. Okay. Counsel, anything additional?
No, Your Honor.
So contact court services once you're released, either by phone, they'll give you instructions. You need to report as directed. You should know the drill by now. Any questions?
No questions.
No,
Thank you.
Good luck to you. And with that, this matter is adjourned.
Thank you.
I see that there is an individual seated there at the Butler County Jail's Zoom location. Who is there?
D. Hoff.
Okay. This is State of Kansas versus Joseph Beylong D. Hoff, case number 2025 CR 553. Mr. D. Hoff appears from the Butler County Detention Center's Zoom location. Cheryl Pierce appears for the state of Kansas. Mr. D. Hoff, there is a charge before the court of disorderly conduct, a Class C non-person misdemeanor, based on an incident allegedly taking place yesterday. How do you desire to plead at this time?
Not guilty.
Court will accept the plea of not guilty. Mr. DeHoff, can you afford to hire your own lawyer on this?
No, I cannot.
And why is that? Are you not working or?
Not at the moment, sir. I just got out of rehab 3 days ago and I lost my job while I was in there.
All right. Court will find that he's indigent currently and will appoint a lawyer to represent him. Darren Patterson will be appointed as his lawyer. We'll set the next court date for this individual, March 2, 2026 at 8 o'clock in the morning. That's a Zoom docket. You must fully participate March 2nd at 8 o'clock a.m. Mr. DeHoff.
Okay.
Judge, I'm sorry. Can you give me that date again?
March 2, 8 o'clock a.m.
Thank you.
Judge Webster's court. All right. What bond is recommended here for Mr. DeHoff?
$2,500 or $2,500 cash or surety bond. It sounds like there's a number of eyewitnesses to the incident. As far as his convictions, he has a 1997 possession of Mara and Para, which he got diversion for. There's also a 98 misdemeanor possession of a stipulant. There's also a 22 distribution and a 24 opiate and a 25, or rather a 24 arrest for domestic battery out of the city of El Dorado. If he is to get released, we would ask that there would be no contact with the co-defendant.
Okay, who's his co-defendant?
Judge, I believe that is Plummer. Amanda Plummer.
Okay. Anything you want to say in response to all of that, Mr. DeHoff?
No, sir.
So you are able to make a $2,500 bond?
No, I don't. I have no money.
Where do you live, Mr. DeHoff?
I live in Douglas.
With Ms. Plummer?
Yes, it's my house, sir.
Okay. What do you mean it's your house? You're on the rental agreement or you own it?
Yes, my name's on the lease.
And hers isn't?
No, sir.
Okay. How long have you lived in Douglas?
I've lived there most of my life.
You think you can get another job if you get out?
Yeah, I should be able to get a job pretty quickly.
Court understands the reasons for the recommendation, but the court's going to set bond in this case at $2,500 OR,
I'm going to let you OR out at this point. Mr. DeHoff, you've been in jail for a little while. Hopefully things have settled down, if you will. You can return home if you're the one on the lease and Amanda Plummer is not, but you can't have contact or communication with her.
I understand.
As a condition of your bond. We're going to keep you two apart.
I understand.
2,500 OR. Make sure you get that court date down on all your scheduling calendars so you don't miss that court date.
Yes, sir.
Okay. And Darren Patterson is appointed as your attorney. All right. Anything further the court needs to address at this time, Ms. Pierce?
Yeah.
Mr. DeHoff?
No, sir.
Very well. There's nothing further then. The Hoff matter will be in recess at this time. We'll move on.
Thank you, sir.
Amanda Plummer?
Yes, sir.
This is State of Kansas versus Amanda Don Plummer. Case number 2025 CR 554. Amanda Plummer appears from the jail Zoom location. Cheryl Pierce on behalf of the state. Ms. Plummer, I have a charge before me in count 1, disorderly conduct, a class C, non-person misdemeanor. Charged as a domestic violence designated crime. How do you plead?
Not guilty.
Did you say not guilty?
Yes, sir.
Okay. The court will accept the plea of not guilty and establish a future court date. Ms. Plummer, I had, I think, a co-defendant in here earlier, Mr. DeHoff. You know who I'm talking about?
Yes, sir. That's my husband.
Okay, well, he claims that his name is on the lease and yours isn't.
I've lived there for a year and a half.
Yeah, I know you may have lived there. His name is on the lease and yours isn't. And I'm going to order that you two stay apart. No contact or communication. Okay? So to get your stuff, you're going to have to relocate temporarily, first of all.
I understand that.
If you make the bond that I'm going to set. Okay?
I can't call anybody to get out of here. I don't know anybody's phone numbers, so I'm stuck here.
All right. What would a bond recommendation be on Ms. Plummer? Ms. Pierce?
Judge,
We didn't even touch each other.
you
We're not going to sort that out today.
you gave Mr. DeHoff a $2,500 cash or surety or OR bond.
I remember.
I don't necessarily have a problem with that necessarily. I would tell the court that she does have a TR case, a 24 TR 2336 that I think is actually
I had the fine money to
in
pay on
front
it
of the
last night,
court
but the
as
person who
well.
called us stole it.
And that has a $5,000 cash or surety bond on it.
I see that. Thank you, Ms. Pierce.
Uh-huh.
There's a second file on you, Amanda. 24 TR 2336. I do see a bond here from Owens Bonding, $5,000 bond. It's never been approved by the court. So, Ms. Plummer, did you make the bond in this case, and then now you're just being held on this new disorderly conduct deal?
Yes, sir. Sunday I turned myself in on that one.
Okay.
And was released. But Mr. DeHoff has my cell phone and I have no way to contact anybody.
Well, that's a bummer.
Tell me about it. He has all my property too, which he's gonna get out and destroy.
Well, that would be another issue for another day. All right. Plea of not guilty. Can you afford to hire a lawyer, Ms. Plummer?
No, sir. I was just robbed of everything I own.
Who was appointed as counsel for DeHoff?
Darren Patterson, and Darren Patterson was her attorney in the TR case, Judge.
Okay.
So I'm here.
So I'm going to have to appoint separate counsel for Ms. Plummer at this point. Court will appoint Shannon Cooper to represent Ms. Plummer in this case.
And are we talking about the 25 case, Judge?
We are.
Okay.
I don't understand any of this.
You were bonded out in the traffic case for today. So you don't have another court date set on that one.
I have court today at 1:30 on that one.
Okay. Was that set in this court or with Judge Lee?
I have no idea. I just knew that
I have another judge having a 1:30 docket today handling cases such as this. So I just want to make sure that you're not before.
My piece of paper said the 19th at 1 or 1:30.
Okay.
It is, Judge.
I think I would rather see this case sorted out sooner rather than later. I'm going to set Ms. Plummer's cases oral for January 2 at 1:30 p.m. before Judge Lee.
I'm here till January.
So January 2, 1:30 p.m. setting for both of these cases. Shannon Cooper appointed in this one. I think the court there may have to address new counsel on the traffic case, but that's why I think we ought to have this heard relatively soon. All right, so an attorney in this case has been appointed. We have a court date set on both cases. He's made bond in one case. Ms. Plummer? Still with me?
Yeah.
Do you have a place to go other than Mr. DeHoff's house?
Yes.
Where?
My
Where?
son's house.
Where's that?
Belle Plaine, 314 Logan Street in Belle Plaine, Kansas.
Okay, and your son knows that you might have a plan to come there?
Yes.
Okay.
But I can't get out of here I can't call anybody.
Just a minute. Just a minute. Ms. Plummer, I want to set the same bond that I did for Mr. DeHoff. I'm going to give you a chance to show up for court when you're supposed to. And you actually have a surety bond, I think, on the other one.
I think
you
it
do.
is. I think that's
Since
what
you're
she's.
under surety bond on a related case, I'm going to go ahead and set an OR bond for you on this. So if you don't have any other holds, you can get out today, Ms. Plummer.
Thank you.
Okay. But you can't have any contact or communication with Mr. DeHoff
If he's not bonded out, can I go to the house and get my property?
He got an OR bond too, so he is going to get out.
So I can't get my clothes or anything.
Listen, what I'm telling you. Well, how you need to proceed is like this. Surely there's a trusted person that can be a go-between between you and him.
Our trusted person is the person who put us in here and told you guys that we were fighting when we weren't.
Okay,
Yeah,
I don't
tell
know
me
who
about
that
it.
is, nor do I care. All I'm
I know
saying
you don't care.
that if you had a third person who could contact Mr. DeHoff and set up some arrangement to get your things, he doesn't have a right to your things, okay? And I would hope he would recognize that and make some provision through a third party to get you some of your stuff. That's the only communication between you and him that I'll allow, and that is through a third party to try to get your stuff back. That's the only business that you would have with him right now. Okay? In the meantime, stay with your son, do the best you can. And then the matter maybe can be addressed further before Judge Lee on January 2. All right? So
I don't plan on returning to the house at all, period.
okay, good. And again, as long as there's peaceful and non-harassing and productive conversation between this third person and Mr. DeHoff, it's not going to be a violation on your part. Okay?
I don't plan on having any contact with him for the rest of my life.
Okay, fine. All right. So we've got our court date set, attorney in this case addressed, and she's on OR bond in this case, surety bond in the other. Anything else, Ms. Pierce, we need to address?
Yeah.
Okay, Ms. Plummer? If there's
No.
nothing further then?
No, I have no idea what's going on, so I don't have anything to say.
Okay, very well. Then the Plummer matters are in recess at this time. We'll move on to other cases.
All right, Tierra Norman. I guess the attorney for Tierra Norman's not here. I have not heard nothing. Nothing at all. Nothing, not a thing. Santa has come and gone. Sorry.
We may need.
Come and gone. Oh, where is Tierra Norman?
She's vacationing on the back.
And should we get some copper tone back there or what? Do we need her out here? What is this? What are we doing for them?
We need a little bit of guidance here.
Do I look like Edgar Pond to you?
This is an MTRP from the shoplifting case with a new case that has some prior history. We had a court hearing 2 Mondays ago or last
We have
Monday.
an NPRP and a new case.
Right. We had a court hearing last Monday and she had car trouble and appeared here at about 10 o'clock instead of 9. I was gone, but she did show up. And you placed her into custody.
Yep.
So
I think that was one of the reasons.
So I had an active warrant for her arrest.
Mm-hmm.
It wasn't because she was late. She also had another. It was 2 reasons for the NTRP.
Oh, yeah, for the FPRP. Yeah. And this case happened in June and the MTRP wasn't filed until a couple of days before December 4th. In this case. But he had a court hearing on the 9th.
She wasn't indicted until September 10th.
Right.
And
the MTRP was filed, I think, December 4th. They're asking.
yeah, well, that.
And the next court date was December 9th. She had a court date on the 9th. She knew about the warrant and she knew that she'd have to take care of it. So I filed prior to the 9th a motion for the court to consider a bond.
Okay.
So
Where
this is,
you want to add?
well, this is the holiday season, Judge, and
Where most thefts occur.
She was doing.
I know you. How many thefts are too many? In your indictment, how many prior thefts are alleged in your indictment? This is your life. You know more than all of us about your life. Let's see if you can guess correctly. How many theft convictions are in this indictment? Previous that you've been convicted of? How many? Ma'am? 9. 9. And then we've got the new indictment. And now the new motion to revoke probation. How many is enough, my goodness? Don't you think going to jail the first time would have said, oh, that's like sticking my hand on a burning stove. I'm not going to do that. But you're not just sticking your hand on it. You're embracing the burning stove. Now you're embracing it. It's like it almost, this is what you do. What you enjoy doing because you're doing a lot of it. Anyway, but we had for the first, at the very first one, some court, maybe probably wasn't, it was probably a kind of court. They made a deal. It was important and said, hey, look, you're going to go to jail if it's. Now you're going to a prison. You can go to prison now because you've had some. When you steal a pack of gum, it's a felony. If you steal a pack of gum, it's a felony the rest of your life. That's because you've gotten this. But no, I can't. As much as I'm the gift giver, but at this time of year, no, it's like me sending a DWI person out there. This is where people steal the most and where they drink the most. And unfortunately, you are paying for your actions. You're being held responsible. And the people who follow the law, most people, they don't feel sorry for you. I mean, maybe the first time, okay, you made a mistake. Everybody makes mistakes, but this is your 10th mistake. They're saying this is your 10th one. No, you're what you are. It's turned into your personality until you can prove that you're much better.
And proving that they'll alone.
No, it's-
I have to plead the
no, yeah, I'm sorry. No, you're,
And I
you were
work-
previous, no, oh, let me speak.
Yes.
9 convictions. Your last one is in this court on November 21st of 2024. So how did you celebrate that? A few months later, you commit a new one, and it resulted in this indictment here. So this is your 10th one. After we made a big deal about it, and you went right out, and didn't take you long before you were stealing again. But no, we're not. We're going to resolve this before. We're not. And there you are at Dillard's. Just stealing, trying to steal stuff at Dillard's, which is why the prices are so high at some places, because not Dillard's necessarily, but at some places, prices are high because the honest people who purchase things have to pay for the losses that result in higher prices because of the people who steal. And that's why jurors on thefts, they don't find it amusing because they're victimized by the prices. Generally, they're not criminals who are in the juries. That's why people hold people accountable. But no, your motion is to. I wanted a motion. Do you want? Well, when do you want the motion to revoke probation hearing? As soon as possible, you can do it.
Your Honor, we can enter a plea of truth.
She's not going anywhere. I'm not going to release her until I get onto the record all the underlying facts and then I'll make a decision. But this is a tall hill to climb. What do you want to do today?
Well, if
I'm denying the bond.
You're denying the bond. The case is the case in reference that I think it's clear what happened and the result of it. And I guess
You want some time though to put together something that can convince me that she's not that she should not be sentenced to the maximum.
we do have
You give a chance.
semi-agreement of the PAP 12 judge.
No, it's going to be no. No, it's 10. My God, it's 10. The message we send after 10 convictions is no, you're going to get a break. Oh my God.
Well,
that is a terrible message to send, especially at Christmas time.
Let me try this option, Judge. You're not by the head.
Do I look like Santa Claus?
I know. In order to push this along,
yes.
If she will enter a plea of truth to the new offense and then ask for a PSI report so that we could come back here and decide.
Okay.
And based on what you do, then the new offense would coincide with that.
All right. That's what you want to do.
That's what we want to do. Okay.
Is that right, ma'am? All right. Then we call 22-41231, the state of Texas versus Tierra Norman. There is a motion to revoke probation that has been filed as of December 4th, 2025. You were here with Mr. Burbank, your attorney, and the state's attorney and probation official. First of all, does the defendant waive any additional time she may have under the law to prepare? Because I think she's got a few more days here that she could wait.
Yeah, this offense happened in June of
No, I'm talking about when it
25,
was
and they
filed.
were aware of that.
This was just filed on the 4th, and I give everybody 30 days after a filing to at least be ready for an announcement. But if you want to waive any additional time that you may have under the law for a preparation, Mr. Burbeck, on behalf of the defendant, are y'all ready to
Yes.
move forward? And does the defendant waive any additional time she may have?
We do, and we ask to proceed. I believe that what we've done, you want comp one, which is saying.
All right, raise your right hand, ma'am. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? You have to speak out so we can hear you. May we proceed in summary? This should be the formal reading. In summary, this motion to revoke probation alleges that that on November 21st of 2024, you were sentenced to 2 years in the state jail, and that was probated for 2 years in this criminal district court of Jefferson County, Texas. If you sentenced to 2 years in the state jail, probated for 5 years for the state jail felony of theft of service. Is that all true?
Yes.
Allegation 1 states you committed the offense of theft of property on or about June 30th, 2025, in violation of your probation order, which is what is represented in this new indictment 25 CL 1242, where you're charged with the state jail felony of theft of property. And I believe this is from the Dillard's department store in Beaumont. Is all of this true and correct? Are you pleading true to this allegation voluntarily and because it is true as it is alleged?
Yeah.
Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation by preponderance of the evidence or greater? Your probation can be revoked, and you could be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today? I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. We're going to order an updated report from probation. We will return back on January.
It'll be either the last week of January or first week of
Can we get the last week in January?
yeah.
As fast.
Please. Okay.
Yeah.
All right. And then all parties can add anything else you wish. Court will make its decision, and then we will take up the other case and see what direction that the pending criminal case for which the new motion to revoke probation is essentially based upon, what direction that may take. Do you understand what has happened today, man?
Yes.
What is your plan on living honestly from here on? Are you committed to doing that?
Yeah. Just trying things for my baby.
But you're still stealing. I know you, but hold, let me see this. Yeah, hold on. You know, I'll ask you to be straight with me, but don't blame your little baby. I mean, your convictions date back 12 years. How old was your baby then in 2014? You can't blame it on your baby. Yes, you did.
It was basically toys for the child.
Yeah, I know, but what happened in 2004? I mean, you got 9 convictions ago. What was the reasons for those? You know, there's always a reason you can find out, but you have to follow the law. And this is material stuff, I know, but.
How old was your child?
I have 5, so my first one was.
Well, you're stealing to, you've got 9 convictions because you were getting toys for your kids? All of those? No, we know better. Right, we'll see you. I need Colton Barrera, Mr. Lane, Brian Lanus, his attorney. Got all your shopping there, done there, right?
No, sir. No, sir.
I just this week completed all my Christmas shopping for last year.
Okay.
Yeah, for last year's Christmas.
Okay.
Now I got to start for this.
Things to say.
A little behind.
I thought
This court is so busy, I hadn't had a chance to even to get on Santa's lap to talk to him about what he needs to bring this year.
That's shitty. That is.
All right, let's get to business here. You were Colton Michael Barrera.
Yes, sir.
And this is clause number 24 CR 687. And in this case, there is a motion to revoke probation that's been filed. It was filed on September 19th, 2025. And in summary, as you probably know, but for the record, this states that on June 19th of this year, God bless you, you were placed on 6 years deferred or unadjudicated probation for the offense of assault on a family member. And let's see, looking at that indictment, said intentionally, knowingly, or recklessly causing bodily injury to a member of your family, household, or person with whom you had a dating relationship by pushing that person down with your hands, and you didn't intentionally, knowingly, and recklessly impede the normal breathing or circulation of the blood of the victim by applying pressure on the person's throat or neck and blocking their nose or mouth with your hands against the peace and dignity of the state, signed by the grand jury foreperson. So that constituted a third-degree felony. So you were placed on probation June 19th, 2025. Is all of that true and correct?
Yeah, yes, sir.
Okay. And raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, lower your hand. And once again, you were placed on probation in this court for 6 years deferred or unadjudicated probation for assault on a family or household member by impeding breath and circulation, a third-degree felony, and you were placed on probation June 19th of this year. Is all of that true?
Yes, sir.
Now, didn't take long. There's a motion to revoke unadjudicated probation that was filed September 19th, which would have been exactly July, August, 3 months after you were placed on probation. Number one, it states that you committed the offense of assault, family or household member by impeding the breath or circulation on or about August 4th, 2025 in Hardin County, Texas, in violation of condition 1 of your deferred or unadjudicated probation order. Do you understand what you are charged with here, sir?
Yes, sir.
Do you? He says yes for you, but is that true? Yes?
Yes, sir. Yes, sir.
Okay. Then number 2, and this says this is in violation of condition 1 of your probation order, which is do not commit another offense against the laws of the state or any other state or the United States. The second allegation states you committed the offense of interfering with emergency requests for assistance on or about August 4th, 2025 in Hardin County, Texas. And that must have been something arising from this other incident in violation of condition 1 of your deferred or unadjudicated probation order. Where is that found, that crime?
The impeding or are you talking about
that one? Interfering with the request for assistance.
It's in the.
Is it in the penal code or in
That's in the penal code too.
Interference 42. Yeah, 42.062.
Yes, sir. Somewhere near the harassments and the stalkings.
Okay. 42.062, interference with emergency requests for assistance is exactly what was alleged here. An individual commits an offense if the individual knowingly prevents or interferes with another individual's ability to place an emergency call or to request assistance, including the request for assistance using an electronic communication device in an emergency from a law enforcement agency, medical facility, or other agency or entity, the primary purpose of which is to provide for the safety of individuals. An offense is a Class A misdemeanor, except that the offense is a state jail felony if the actor has previously been convicted under this section. Which I don't think that's what he was convicted of.
Yes, sir.
Okay, so do you understand what you're charged with in allegation number 2?
Yes, sir.
Yeah, speak out. Okay. What are we doing today?
Bond hearing. Yes,
Is that right?
Yes, sir.
What's his bond line now? No bond?
No bond, because he was transferred from Hardin County to here. You wanted to have.
All right. It's your motion. Go ahead.
Okay. Your Honor, I guess we'll just start with, basically, he's on deferred, so his.
Okay, I know. You have
Here's what
data or testimony to present?
No, sir, except that the allegations in the motion to revoke probation for the probation that he's on, he is entitled to a bond. Here's what has happened, if I may proffer. In Hardin County, he's been in custody since September. He made bond in Hardin County and they put terms and conditions of release on him. So he already has a monitor. In fact, he's wearing that on his leg.
Mm-hmm.
He already has terms and conditions of distance. He already has terms and conditions of contact. He has many terms and conditions. There may be a term and condition that the state requests, but at this particular juncture, we're respectfully asking for a reasonable bond, a bond at around $25,000. And I think the state has a request for a condition that they'd like the court to consider.
Don't tell me the victim in this case is the same victim in the underlying indictment. Is it?
No. The underlying.
A different victim?
It is a different victim. This is the
victim advised that her fiance, the defendant. Okay, this was fiance.
Yes, this was a that type of relationship which ensued after he got on probation or while he was on probation.
So the original
right after
on the original case, he was placed on probation, or he was accused of assaulting the mother of his children. Is that right?
No, sir.
No,
no, sir.
It says
Just a girlfriend, but
it says as over the way their respective children treated each other.
No, sir.
The way it reads, what was the relationship with this first person?
girlfriend.
A different girlfriend,
Yes, sir.
but a girlfriend.
Okay.
Okay. Go ahead. What else?
I guess that's what we're asking as far as bonding. That you uphold the terms and conditions that are already on him from Hardin County, which he has the monitor and everything else.
Who is there a probation officer?
No, Your Honor.
Did somebody have a pre-sentence report?
I do, Judge. I'll have to print it off, but if you're looking for his priors or what was alleged in the pre-sentence report before,
Yeah, I want to see what.
I show in February 27th, 2022, he had committed an offense of assault causing bodily injury to a family member, was given 1 year deferred probation on November 15th, 2022. And then on November 21st, 2023, he committed this offense that he's on probation for. So it was just shortly after he got off probation on the misdemeanor.
So this is going to. So this new allegation would be a third different assault on a family member?
That's correct, Judge.
Within how many years?
Well, 2022 was the first one, February 27th, 2022. Second one occurred November 21st, 2023. And then this one was on probation for this. I think he was placed on probation June of 25 and committed this offense September 25. So if there is a bond, which I think under the deferred he generally is entitled to, but he's committed a felony while on probation for another felony. They'd ask for an extremely high bond, at least 250,000 plus home confinement if he gets it, and no exceptions of leaving his home, not for work, not for anything other than seeing his lawyer.
Now, Your Honor, his family is here.
What did they have to do with any of the alleged assaults?
That's
what I'm worried about. The families, they're always going to be here.
No,
let me speak. The family, this is what's annoying about it. They're here. Okay. This is the third assault in just a short period of time by a close member, a relationship, who has a relationship with these people. That's what I want to know is what's the family doing to keep that from happening? If they're not involved in the deterrence of it, I don't need to hear them. I really don't. Let me speak and finish.
I'm sorry, I thought you were. I apologize.
How can you do? I'm still speaking.
I'm sorry.
We can't, but we can't both speak. We're going to
Okay.
take one at a time. But family assaults are the most dangerous and the volatile of them all. And that's why we're very sensitive about this. And this is, three uniquely similar situations. And he's when somebody puts their hands around someone's throat and squeezes, there's only one intent, and that's to kill.
Well, that is.
No, don't interrupt me. I'm still speaking. You're going to have a chance to respond. That's exactly what it's all about. You got to breathe. And when you prevent somebody from breathing, they're going to die. And that's in the underlying indictment. It's alleged in the indictment that he pleaded guilty to. Then we got, let's see, a prior conviction, you said, Mr. Leary?
Yeah, it's prior deferred probation.
For what offense? And that was in 22?
Yes, sir. He was given, the offense occurred February 27, 2022. It was assault causing bodily injury family member. On November 15, 2022, he was given 1 year deferred probation. And then he committed.
What was the underlying facts of that? Does it show?
The first one?
How the assault occurred?
Let me see if I can find that.
But while he's doing that, here's on this one, on August 5th, committed the offense of assault by impeding breath or circulation again. He strangles people. No. What do you do when you stick your hand around somebody's neck and squeezes? That's strangling.
That is your arm.
All right. He's done it twice, according to this. And then I want to know what happened in the first case of his first love interest. Man, that's just incredible.
We get to the probable cause, Judge.
Yeah. Just on a side note, you're getting it all wrong. You're supposed to respect and care for the people you care for and love.
Yes, sir.
Not strangle them.
Yes.
Okay. I didn't know if maybe you didn't understand that, but you understand that clearly.
Probable cause as on Sunday, February 27th, 2022 at 3:16 hours. Officer dispatched to 1205 MacArthur Drive, reference to disturbance, possible assault in progress, called in by a juvenile. Upon arrival, officers on scene overheard a loud thud and upon entry found that the accused, Colton Barrera, was assaulting his living girlfriend of 1 month by throwing her inside the bedroom up against a wall multiple times, causing her pain and bodily injury. Barrera was observed to be intoxicated as the assault occurred after he had arrived home angry. Barrera was placed under arrest for Class A family violence.
All right, you go ahead.
Thank you. What I'm going to say is that the families here, when they hired me, the very first thing I tried to do was get him civilly committed with a committal because he's been diagnosed as bipolar. Now there's extenuating circumstances and facts that are part of this new case. That's when his family came to me, and that's when I began to do it. I couldn't get it through the county judge to try to get that. Otherwise, that's where I was trying to get him back on his meds, back where he needed to be. And that was the whole process of them hiring me.
What medication are you talking about?
his medication for his bipolar disorder. He has major depressive disorder. Of course, he has ADHD, but he
How long
has
has he been
bipolar.
on medication?
Since how many years?
Not taking it for probably 5 or 6 years consecutive.
Oh, wait, okay. So whose fault is it he's not taking the medication that was obviously prescribed for his situation? Whose fault is that? Who's keeping him from swallowing the pills?
Right. And
Who's doing that?
well, his family has come in and tried to start do that. They tried to take him.
No, it's his choice, right?
Well, yes, sir. But I'm just saying, as far as the family, where's the family going and where is his support team? He has a support team. I tried to get him into Oceans. Oceans was considering taking him, which is a long-term treatment facility for mental illness and other disorders. I couldn't get the committal into MHMR or B&H in order to get from there to Oceans. And so that's where we are. When I asked the court for a bond, the court said no. Bring
I'm asking, here's what I'm more concerned about. Is he competent mentally? Do we need a competency evaluation?
He's been able to speak with me.
Yes or no?
No.
There's not a question about that?
No, sir.
So the choice is his. How do you prevent that? They can come in and help him all day long, but he's got to swallow. He's a grown-up. When we're diagnosed with something, unless we're incompetent or unable to take care of ourselves, he's out there alone. He's or independent, and as long as he's independent, he's got responsibilities. When you're diagnosed and you have medication, you're supposed to take medication. If you refuse or fail to do that, that's your fault.
Yes,
And other people are getting their necks squeezed here. I'm sorry, the family can't do anything. He's the grown up too. Either he's competent. If he's incompetent and the family has to help do that, then okay, but he's ambling about as an independent human, and that has responsibilities to it. You've got to not harm anyone, follow the rules,
yes, sir.
and give each person respect. Those are the 3 requirements. Don't harm anybody, live peacefully, and give each person respect. Well, this is the 3rd event of a similar fashion that's being alleged here on this court's watch. And I've got problems letting him go out independently when he has had 2 situations here and is not acting independently with wise choices and responsibly. And we're not just talking about he curses at someone. He's squeezing people's necks. He's had a habit. He's got a history of that, which can cause death.
Yes, sir.
All right. There's a lot that needs to be done here. Which is consistent pattern in just a few years that should have been addressed before this, but nonetheless, it's on my watch, and then I'm going to address it.
Yes, sir.
But we're going to do it responsibly and in a aggressive manner that moves forward. Because I'm not going to put another person who gets assaulted while he's on a motion to on probation on my watch. They'd say, "Who's to blame?" on the front page, and it'd be my picture.
Yes, sir. I understand. Now, some of his competency is based on what we did in the Hardin County Jail to get the doctor to see him and get him medicated and get his medicine to be here. So where he's at right now is medicated. The terms and conditions that the court has to put on him from home confinement, the monitor is already on him. He has the leg for that with all the other conditions.
He was told by his doctor to take medicine, right? He was told by his doctor to take medicine, right?
Okay.
And he's not doing it.
Well, he's been doing it in the jail.
No, did he? He's doing it in the jail now. But I mean, when he's in the free world, he made a conscious choice not to.
No, but he is Medicaid, has medication. So, I mean.
But doesn't it have to be imbibed, taken in, and swallowed?
It does.
That's and he's not doing that.
He is
That's
doing
what
that.
brings him up here.
Well, he's doing that at this point, Your Honor. If you put it, if he,
Because you know why? Because he's in jail and they're forcing him down. It seems like that's where he needs to be to ensure that he will stay medicated.
that's not a forcible thing. He has voluntarily taken his meds. They've never had to do anything like that.
So he intentionally didn't.
He wasn't taking his medication, Your Honor. But as far as the ability to have bond, he's entitled to bond with terms and conditions that this court can put on him. And home confinement, taking his medication with his family. He's not living by himself. He'll be living with his mother and father until we get this resolved.
Anything else?
No, sir.
All right. I'm going to agree. He's entitled to a bond. $250,000 is the bond. If he posts the bond, he will be home confinement. He cannot leave except with someone from the family escorting him. He has to be with a family member at all times. And they can bring him to and from your office, to and from court, to and from the doctor. He has to have a GPS device, so I know where he is at all times. And he has to take the medicine that he is prescribed that he doesn't seem to take. What other conditions are the state asking for?
Well, of course, their standard bond conditions are no contact with the complainant, either directly or indirectly.
And can't have any contact with the victim, and that's in all cases. Now, are y'all ready for a hearing in January?
I think we would need to get discovery, but what about?
What discovery do you need?
Discovery on the case.
It's going to be discovery on the new case that they have in Hardin County. They'll have to.
How long is it? How long?
First, I heard you say you had an opening at the 1st of February.
Yeah, for him.
Do we have MTOP hearings first part of February?
That's, well, that was just one.
I can set one. Guys.
Yeah, we set them when we were able to squeeze them in, and but when we do some dates on MTRP hearings,
Yes,
most MTRPs are not contested, but the ones that are contested, so you don't know how long it's going to take. So we'll set it though in first part of February, and she'll let you know, okay,
Yes, sir.
when she can iron it out after the first of the year.
Okay, that sounds good.
All right.
Go from
What
there.
else?
I think that's it.
What's the status of this Hardin County case? What are they doing on it?
They're indicted and they're moving forward.
They are going
So,
to indict?
yes, sir.
Well, do you know when?
They've indicted.
Oh, it's already been done.
It has.
Do you have a copy of that indictment? When did they do that?
I don't know.
They did that,
Okay, so the grand jury deemed probable cause that he committed a crime.
yes,
Okay.
on,
Hey, do you have a copy of this?
Of what?
This indictment?
No, Your Honor, do not.
Can we make copies for everybody?
yes, sir.
Because I want one, and the state ought to have one.
Yes, sir.
And then, thank you. Is he getting all his medicine? He's been diagnosed to.
Yes,
Okay.
we have aggressively pursued that avenue. I mean, that has been progressively pursued since day one. Just dealing
You're
with.
gonna have to figure, I have to tell you what to do, but you're gonna have to figure what's failing here. The doctor's doing their part. He's got to be doing his part. How are you gonna ensure that that's gonna be done as your test?
Yes, sir, and that was part of.
Because man, next time, shame on somebody else other than him.
Yes,
Somebody is, what in the world? How many times does this have to happen?
But there's a support team dealing with his medication.
It has to be effective. It has to do the job.
Yes, sir.
Whatever it is, but failure is not an option here because he's looking at going to prison
I know. Yes, sir.
unless the fact finder can be convinced,
Right.
because all that comes up at a trial or a hearing of past misconduct, and it's too similar.
Yes, sir.
Everybody asks, what's the problem? We all take medicine to some degree, but we take it
I'm hoping to have.
like it's diagnosed, or else it's our fault.
Yes, sir.
Okay. Make sure here. I think this is yours. This is.
Thanks, sir.
Yeah, I got a copy. All right. What else to add right now?
I think that's it, Your Honor. We'll probably get with the state and deal with discovery, and we'll go from there.
Okay, Brian, okay. All right, if something happens before this, let me know that we need to take up.
Yes, sir.
That might help you.
Yes, sir.
You know, that's, you feel like I need to hear that can make a difference in where the orders are.
Yes, sir.
Okay, what else? Anything else? Mistake?
No, Your Honor.
We're recessed.
Thank you, Your Honor.
Go, Matt.
All right, we will go on the record in the matter 24 CM 38, 25 CF 77, State of Wisconsin versus Derrick Williams. The state appears through District Attorney Kevin Schmidt in person. Mr. Williams appears in person, by video conferencing in custody in Burnett County Jail. This is a return on warrant initial appearance. Warrant is quashed. We will address bail momentarily. If we need to. Mr. Williams, you have written the court a few letters, and in one of the letters, or maybe in a couple of the letters, you indicate that you wish to represent yourself. Is that correct?
Yes.
And so I need to go over a few questions as it relates to that. How old are you?
34.
Can you read, write, and do you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Okay, Mr. Williams, do you understand that a lawyer goes to law school so that they can learn about the law and learn how to negotiate and look for defenses in a case?
Yes.
So do you understand that there are certain advantages to having a lawyer?
Yes.
And do you understand that there are certain disadvantages to not having a lawyer, such as the fact that you did not go to law school, so you may not be as savvy in those areas?
Yes.
And you wish to represent yourself today in this case, is that correct?
Yes.
All right. Before we proceed, you are appearing by video conferencing. No, I will ask that later. But Mr. Schmidt, is there an offer that could be presented right now to Mr. Williams since he is representing himself?
The offer the state would make in this case is a plea to count 1 in 25 CF 77, the felony unauthorized use of an individual's personally identifying information, giving someone else's name. We DRI all their counts and we'd agree to costs and the time he served. The main reason we're offering this is he keeps missing court and he's already forfeited a very large amount of cash.
All right. So Mr. Williams, if you wish to accept that offer, it is a felony offer. I could take care of that here today, and then you could be resolved and on your way. Is that what you wish to do?
Well, not necessarily, being that I do believe it was a misunderstanding of.
And that's fine. You can, if you wish to contest this, that's fine. We can go the normal course down the path and down the road of the justice system. That is totally fine. With here today, you have missed a significant amount of court, and I do understand that you stated that you were in Pine County on your last court date, or maybe even a couple of the last court dates that you missed. I don't look at that. It's your problem, your excuse, your reason. That's why you were in Pine County Jail. My court requires that you make all court appearances, and being in custody in another jurisdiction doesn't qualify for this court in this county. So the court is going to set bail at $2,500 cash, same conditions as previously noted. If you wish to accept the offer, we could take care of that here today, if that's what you wish to do, or I can set this matter, we can move forward in normal course, have the initial appearance here today, and I can set the preliminary hearing for January. So did you receive a copy of that criminal complaint?
Yes.
And you can read, write, you understand the English language?
Yes.
So you were charged with 1 count of identity theft avoidance on or around June 1st, 2025 in Burnett County, Wisconsin. It is alleged that you intentionally used personal identifying information or personal identifying documents, a Minnesota instructional permit of MLN, to avoid civil or criminal process or penalty without the individual's authorization or consent by representing that you were that individual or you were acting with the authorization or consent of the individual. That is a Class H felony. Upon conviction, you could face up to $10,000 in fines, imprisonment of more than 6 years, or both. Count 2, possession of drug paraphernalia. It alleges the same date, the same time, the same place, that you knowingly possessed with the primary intent to use a glass bong to inhale a controlled substance. This is a misdemeanor. Upon conviction, you could be fined not more than $500 or imprisoned not more than 30 days, or both. Count 3, misdemeanor bail jump. It alleges the same date, the same time, the same place, that having been charged with a misdemeanor in Burnett County case number 24 CM38 and having been released from custody, you intentionally failed to comply with the terms of your bond by committing a new crime of possession of drug paraphernalia. That is a Class A misdemeanor. Upon conviction, you could be fined not more than $10,000 or imprisoned not more than 9 months, or both. Count 4, misdemeanor bail jumping. It alleges the same date, the same time, the same place, that having been charged with a misdemeanor in Burnett County case number 24 CM38 and having been released from custody, you intentionally failed to comply with the terms of your bond by committing a new crime of felony identity theft to avoid criminal process or penalty. That is a Class A misdemeanor. Upon conviction, you could be fined not more than $10,000 or imprisoned not more than 9 months, or both. Do you understand all of those charges and those maximum penalties?
Yes.
All right. Now, with regards to the misdemeanors, do you wish to enter a not guilty plea?
At this time, as I can remember, it was a miscommunication because he was asking.
It is
me-
not. It's a felony. Do you understand those charges as I've read them to you, and those maximum penalties?
Yes.
Not guilty pleas are entered on your behalf. Are you still at Oshki Udina Street in Hinckley?
Yes.
Telephone ends in 6417.
I don't have a cell phone at this time.
Okay, that's fine. Now, in the other case, 24 CM38, you also have missed that. You've missed that initial appearance. The warrant is quashed on that matter as well. Count 1 is possession illegally obtained prescription. It alleges on or around February 25th, 2024 in Burnett County, Wisconsin, you possessed an illegally obtained prescription drug, a misdemeanor. Upon conviction, you could be fined not more than $500 or imprisoned not more than 6 months, or both. Count 2, possession of drug paraphernalia as a party to a crime. It alleges the same date, the same time, the same place, that as a party to a crime, you knowingly possessed with the primary intent to use a pipe to inhale a controlled substance. Upon conviction, you could be fined not more than $500 or imprisoned not more than 30 days, or both. Do you understand those charges and the maximum penalties?
Yes.
Not guilty pleas will be entered on your behalf here today. The court has set bail again at $2,500 cash, with the same conditions as the previous bond, and that is because you have missed so much court. I don't think I've ever seen you in court before, and I was supposed to see you February 26, 2024, and I did not see you on that date in time, nor did I see you on any of the other hearings that were scheduled on March 6th, March 13th, 2024, May 23rd, 2024, and so on and so forth. It goes on until today. So that's why the bail is set at $2,500 cash. I will reiterate, I am going to set a preliminary hearing. I'm setting the preliminary hearing. Let's see. Okay, preliminary hearing will be set for 2:45 on January 5th, 2:45 on January 5th, a preliminary hearing. That's where the court determines if a felony was probably committed, and probably committed by you. So we'll have that hearing. I will reiterate the offer from the state. As to all of those counts and charges, there are a total of 6 counts and charges. One is a felony, the remaining are misdemeanors. The court or the state has offered you a plea deal of plead to the felony count of misappropriating ID, avoiding a penalty, to dismiss and read in all other counts, and then has offered that it would be a cost only. So money, court costs and fees, and time served for the time that you have served in custody. That is the offer of the state. Do you understand that offer?
I understand an offer, but if I accept the offer, will I have a chance to appeal at some point, or is there a time limit on appeal?
Well, by hearing that, I'm not taking your offer. I'm not taking the plea. This is going down the road in a trial. Yeah.
I'm asking a question because I'm literally by myself at this point. You know, I don't have a computer.
Exactly, and I totally understand that. And by you letting me know that you are looking at the time to appeal, that leads me to believe that you need an attorney to help instruct you and to guide you down the path in this matter. And so I'm going to strongly encourage you to apply for a public defender, so that one can what?
I've already did everything like that, and they said I wasn't. I didn't.
Oh, you don't qualify, right? That's right. You filled out a court-appointed application. I did approve that. We need $500 deposit, and then it's $100 a month. And I need to have an attorney appointed so that they can represent you on Monday. Or on Monday, January 5th.
I was like under seeing if I could like post a smaller bail amount, you know, and work out something like that, being I have some family emergencies that I need to attend.
I understand. I understand your requests. I've read all of your letters. That's denied $2,500 cash because I have not seen you since February 26, 2024. So that's over a year since February 26, 2024, I've not seen you. You haven't come to court, okay? And so that's why cash needs to be so high, because you don't come to court. And also the court is going to put an order out there that you are ordered not to have any further calls with the clerk of court's office or anyone involved in the Burnett County court system, except for the district attorney's office if you are representing yourself. Because I have had word that you have made numerous, voluminous calls, and you are not able to do that. You cannot do that. If you do so, the court can hold you in contempt and can have sanctions against you. Furthermore, you left a message on my voicemail yesterday. I did not hear it. All I heard was, "Hi, this is Derrick Williams." I deleted the message. I did not hear it. It is so inappropriate that you attempt to contact the judge. You do that again, you will be found in contempt. You will have sanctions. You can consider the offer of the state. You can contact the state. I will see you on January 5th. You will have an attorney appointed to you. Anything further, Mr. Williams?
I was just under the impression if I accept the plea offer now, and you said
Mr. Williams, you can contact the state and you can have see if you can give him a call and talk to him about possible resolving this. You can present your own evidence, your own thoughts on the facts, and see if you can present a counteroffer to the state. But right now, with your question to me about are you able to appeal, that leads me to believe that you would just be taking the offer to get yourself out of jail, and then you would be appealing this. I don't like appeals. I don't like to be overturned. I don't like to be reversed. I will not do that. And if I have any indication that you are doing this just to get out of jail, I will not move forward with the plea. You need to have an attorney. An attorney will look at the case with you. Or you can represent yourself. You can speak with Mr. Schmidt and you can talk about a counteroffer to his offer. But that's where we are here today, okay? Thank you. We are adjourned. Mr. Kokesh, can you hear me? You are muted and I can't see you. Mr. Kokesh, can you hear me?
Okay, did that do it?
Yep, that's great. Thank you.
Okay, there's still another window here though. I gotta click. I got bad eyesight.
You're fine. You should be fine. You can just sit down. You're
Okay.
fine.
Okay. I'm sorry.
That's okay. You're not meant to have to run that. You're good. We will go on the record in the matter 25 CF 175, State of Wisconsin versus Jared Kokesh. The state appears through District Attorney Kevin Schmidt in person. We have Amber Sherwood, a public defender, making a special appearance on his behalf here today. We have Mr. Kokesh appearing by video conferencing in custody in Burnett County Jail. Warrant is quashed. Here for a bail hearing. Mr. Schmidt, argument, please.
I would ask the court to set a small cash bond on this based primarily on the fact of how serious the offense was. The main reason we did the complaint, the warrants, we didn't know where to find him because of the circumstances of how the offense went, and police couldn't do that. His history is minimal. He's 41. He has one prior. It's for OWI. So he does not have a history of violence. I don't know the extent to which he has a connection in the community. I think he might be from Minnesota, but that's unclear. Thank you.
All right. Before I ask for argument from Ms. Sherwood, Mr. Kokesh, do you have a local address?
I showed up for a restraining order, and I was staying there. So right now, not so much, but I can't really do anything from here. I agree and appreciate what he said. I'm not violent. I
don't
wish.
need anything else. I was simply asking if you have a place to stay. Yes, you were here yesterday for a restraining order hearing, and you were living with the individual, and you are no longer living with the individual. You came
Correct.
with another gentleman. Is that a gentleman that you intend to stay with?
I would like to, but I can't ask him right now. That's where I was staying from the time of the incident to the yesterday occurrence.
Who is he?
That's where I was staying, yes.
Who is he to you?
He's a brother of the neighbors, and I do a lot of handyman work for everybody in that park and his brother. So I had just done some like odds and ends, clean up the yard, cut some firewood type stuff.
Okay, where are you from?
I was actually born in Hennepin County, but my mom moved here when I was very young. I went to school in Grantsburg. I graduated in Grantsburg, and then I moved to Nevada. And
Okay, is your mom still living?
no, she left us, ma'am.
I'm sorry to hear that. So do you have any other relatives here in Burnett County?
Got like a cousin that was related to my stepdad, but they weren't legally married, so I guess
Okay.
it's not legally family.
That's okay. It's all fine. I was just trying to get a little bit more information, trying to figure out where you're gonna go until this matter can resolve. If you're trying to look to go back to Nevada, if you're trying to look to go back to Hennepin County or somewhere in Minnesota.
When I lived in Nevada, it was because my biological father was there. My stepmom's passed, and he's in a hospital to dementia. So
Okay.
Nevada's not in the cards. Okay. Not going back to Nevada, no.
All right. I don't have much information to go on, Ms. Sherwood.
Yes, Your Honor, we're asking for a signature bond. He has been in the area for the last 10 years, it appears. He
Yes.
does not have any money, as evidence the fact that he qualifies for the public defender. And I will just reiterate, as Attorney Schmidt did, that he doesn't have a long history and no violent history at this time. And this was initiated on warrant where he didn't even know he was being looked for.
I know, it all happened yesterday.
Yeah.
All right.
Well, and I had to call the clerk of courts just to find out the specific time in which to be here. I wish nobody any harm or ill will. I just I would like to get out so I can make the money for the lawyer before it goes up. I think I got 60 days to pay that.
All right, these are serious allegations, Mr. Kokesh. I don't know the actual facts of the case. I don't know how serious it really was or is. On paper, it looks very serious. I'm going to tell you that I got a little bit more information about the incident or what happened yesterday at the hearing through that other matter. I really have concerns that you are of where you're going to stay and if you're going to be able to make your court appearances. But here's the thing. I'm just gonna do this. Can you please raise your right hand?
Sure, yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Let me put your hand down. Do you swear to me that you are going to make every court appearance?
Yeah.
You're gonna come to court. If I tell you you have a court hearing, you're gonna come to court.
Yeah.
And if for some reason you have an emergency and you would like to move the court date, you're going to let the court know as quickly as practically possible and not just miss a hearing, correct?
Correct. Yeah. I mean, I had to hunt information down to show up yesterday. I won't dip on you.
All right. And Mr. Kokesh, you're going to notify the court within 24 hours of where you are staying. And if that is just couch hopping or bedroom hopping or whatever, you're going to continue to notify the court each and every time you move to places to stay. Okay?
Okay, yeah.
Do you have a telephone number?
No, I was using his landline. I do know of somebody who is single, and I might go there for the holiday to give Rob and his family some privacy.
That's all good. I just want to make sure that I know where you're going to be and that there's a way to get a hold of you so that we can have notice of court hearings, etc. Do you have a place to get mail? Can you get it at that friend's house, the neighbor's brother?
I mean, I would like to talk to him about it. I did talk with the court-appointed attorney, and hopefully my ex will just give it to his brother, our neighbor, and not just throw it away. When I get there, I can ask him if I can have mail sent there. I don't want to just send mail there without asking.
I appreciate that, and I'm sure he does too. Here's the deal. We'll keep the address as it is. I understand, Mr. Schmidt, you're asking for money, even if it's low, and generally, this would require some kind of cash, probably higher cash, because I have no concrete information that he's going to be able to be in a place and come to court. However, I'm going to trust you, Mr. Kokesh.
I appreciate
Happy holidays. I'm going to trust you because I want you to get out. I want you to find a job. I want you to find a place to live. And you swore to me on the record that you're going to make all your court appearances and you're going to notify the court when you move places to stay. So I'm going to do $1,000 signature bond, absolutely no contact with victim. There's an injunction anyway, so you can't have contact, no contact with her residence or if she's employed, her employment.
Yeah, stay away
absolute
from
sobriety.
Dairy Queen. I know.
Absolute sobriety, no alcohol, no illegal substances.
Okay.
Okay. And again,
Okay.
notify the court of all of those things. All right.
Okay. I appreciate your trust, and these serious charges scare me too. I don't want a felony record. It's gonna make life a lot harder. I know
That's why you
it's-
need an attorney. That's why you need an attorney. Okay. And you're going to get an attorney. They're going to talk to you. I'm going to schedule this for January 14th at 1.
Okay.
January 14th at 1. Come to court. Okay.
Okay.
All right.
14th at 1. Okay.
That's right. and that'll be on your bail bond, okay? You'll get this thing and it's gonna be your bail bond. It's gonna tell you all the conditions that you must comply with, all of those things. At the bottom where you sign, it's gonna have the date of that court date, okay? So make
Okay.
sure, that's a very important document. It'll have all that you need to know for the next hearing and what you
And
need to
that's the
do to stay
acknowledgement of
compliant.
the next hearing, correct?
Correct.
Okay, yep.
All right? Okay.
I
All right,
understand.
thank you. All right,
No,
we are
thank
adjourned.
you.
This is the Lacey, Tumwater, and county calendar. Folks in the courtroom, which matter are you here for? Just so I have it down.
Cody Calisthen.
You're here for the Cody Hills matter. Okay, thank you. All right. Let's see. Don't have anyone at county corrections, it looks like. There were.
They're there, they're just not on.
They're just not on screen.
Yeah.
Okay. All right. Somebody's in the booth. Is there somebody there in the booth at Thurston County Corrections? Oh, okay.
Just me,
All right.
Cody.
Okay, Ms. Callison. All right.
I'm,
And then,
I just didn't want to be seen. I'm not. Yeah.
okay. All right. Mr. Pesder.
Yes, Your Honor. I know these matters are set, or there's a lot of matters set today. We are still waiting on a Superior Court follow-up competency evaluation. I know Miss Calisthen just gave birth, was in the hospital recently, so I think there's been some delay in getting that evaluation done. But our request today would just be to set these out in an excluded period pending that evaluation.
Okay. I saw that on December 22nd, and I do see that there's a motion to modify release conditions, so we will get to that here in a moment. I see on December 22nd, there was an order of continuance in Superior Court. Do we know what day that's been continued to?
January 5th, Your Honor.
I'm sorry, can I interject so I can have a moment with the attorney?
You would like a breakout room with your attorney?
Yeah, I was under the impression there was supposed to be another attorney here, but no one has shown up, so.
All right, your attorney is on Zoom, ma'am, Mr. Pezderka. He is here. He's just peering remotely.
Man, make me feel old.
All right. And did Miss Calisthen, I heard you say, Mr. Pezderka, and you may know as well, it sounds like she gave birth at this point? Is that on Friday she did? Okay.
To a beautiful, 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 she is the sun, the moon, the stars, and I am totally biased here, but she is the cutest baby ever. And I know I'm biased, but I'm also not wrong.
All right. Well, Ms. Calisthen, and how is your health? Did you deliver? Any complications as far as your health is concerned?
They initially said there was IUGR, which I forgot exactly what that stands for. I think something about the growth rate. Like she came a day early, and something about I have an old placenta. So I don't know how that's determined, but I long to be reunited with her, and if I can say,
Ms. Calisthen, so I think you'll have an opportunity to talk to your attorney here. We can do a breakout room, but before we do that, because I think there's just some scheduling matters we're gonna get through first. And so your next court date, it sounds like in Superior Court, is January 5th. We are not, I don't believe we're in excluded period right now for your district court matters. We're here for trial confirmation and pretrial. So I think, though, what I'm going to do is I do see that there is that competency evaluation that's in Superior Court. I believe Mr. Pezderka, correct me if I'm wrong, but I think the request is to have a good cause continuance, excluding period between now and when competency can be determined. I know we don't we don't have a competency evaluation out of this court, but I do think obviously the one in Superior Court is relevant here.
Yes.
So I'm gonna exclude the period and set a competency hearing for January 6th. So the day after the Superior Court matter. So we'll have some information from Superior Court. So for scheduling purposes, I'll find that we're in excluded period, and that will extend to January 6th at 1:30. Okay. With respect to the motion to modify release conditions, Ms. Pritikin, so I read your motion, and we've got a pretty long calendar. I'll let you filed the motion, so I'll let you, if there's anything you'd like to add, go ahead, and then I'll let Mr. Pazderka respond.
Yeah, Your Honor, I'm not going to prolong this, given that you've read the motion. The issue is just that Ms. Calisthen is using every opportunity possible to make calls to the victim and the victim's girlfriend, and she is calling literally every university she can think of, going through the public health department. She's called insurance companies. She's called our office. She's called Tumwater. It's getting excessive. It's about 11 to 14 calls every single day, and repeated attempts through everybody to contact the victim and other third parties that will contact the victim for her. So that we just need to put an end to that to protect the victim in this case.
Girlfriend.
Okay, thank you. Mr. Pazderka?
Your Honor, while I understand the city's position, I think on principle, we were just objecting to this motion for various, I guess, without getting too, in the weeds. I think that the main thing I would just say is that, we are waiting for that competency evaluation to come back. And just for clarification, I did file a 1077 in the district court case. Originally, there was an evaluation done that came back that I believe had some major issues with the evaluation itself as to whether competency was validly found, and I had raised those at the time. I believe Judge Wilcox still found her competent, and I had indicated at that same hearing that her Superior Court attorney would be filing a second 1077 in her case the day or two after, which did happen, and which is kind of why we're waiting on that second report as well. But essentially, this has been an ongoing situation where we are, I think the issue is the issue of competency and whether Ms. Calisthen fully appreciates the nature of the charges against her, as well as the court orders themselves. So on two bases: one, that I believe it improperly restricts my client's rights, but then also I think it is inappropriate due to the pending competency concerns.
Oh, can I say something?
Ms. Calisthen, I would advise you not to.
I definitely have something to say. I didn't know I was carrying the child of another woman's man. But thank you for enlightening me.
All right. So I'm going to deny the motion. Reason being, I am concerned that folks in custody do have First Amendment rights, that I'm concerned about a restriction to just contacting her attorney and mother. I'm concerned about some First Amendment issues there, considering that that right is subject to legitimate security interests of the penal institution. I understand there's allegations that Ms. Calisthen is calling a lot of folks trying to initiate third-party contact. Again, the allegations initiating third-party contact with the protected party here. I don't think that sort of falls under the case law that I'm aware of that gives the court authority to put some pretty heavy restrictions on telephone access. I'm also mindful that there's cases out of this court, but there's also cases out of Lakewood, Pierce County District Court here, Superior Court here. Ms. Calisthen is going through a competency evaluation. There may be, and she also just gave birth, there may be a wide variety of mental and physical health professionals who may need to contact her. And I'm just not going to weigh in on who she can and cannot talk to telephonically. If the City of Tumwater feels that it has sufficient evidence that she is violating that pretrial no contact order. They are more than welcome to file criminal charges to that extent as well, but I'm not going to impose restrictions on her telephonic access given everything that's going on right now. So that motion is denied. I'm not making any changes to release conditions. There's still bail imposed. There's still pretrial no contact order in place. Those continue to be the case. And Ms. Calisthen, your attorney has advised you not to say anything. I recommend you follow that advice. Things you say that you may think are helpful may be incriminating. So I strongly advise you to not talk to your attorney, or to talk to your attorney before addressing the court. And then Ms. Calisthen, your parents are here in court. Is there any? You've been here for the hearing. Is there anything you'd like to say, or you? No. Okay. All right. Thank you both. Okay.
I know, I would like to say my goal, initially, please let me speak. I didn't think I could do it, being a mother without Rob. I don't know about this girlfriend Crystal situation. I know she is not going to be involved in my child's life, but anyways, that's besides the point.
All right. So Ms. Calisthen, we don't, Ms. Calisthen, I know you want to kind of say your piece here. That's not really the purpose of today's hearing. If you want to talk more about the case, I suggest you talk to your attorney there, Mr. Pazderka. But for today's hearing, again, I'm scheduling a competency hearing for January 6th, and we're not taking any other action on your cases today. All right. Okay, thank you, ma'am. You're free to be taken back, and we'll see you back on January 6th, and that's going to be the next hearing in this court. For you. 1:30, yes, that's correct.
That is all I have this afternoon, Your Honor.
All right, thank you, Mr. Pazderka. So, okay, Nisqually, what's your name, sir?
Xavier Jackson.
Xavier Jackson. All right. Full name Xavier Alexander Jackson?
Yes, sir.
Date of birth, September 17th, 2001?
Yes, sir. I don't know. I mean, I know this is pre-trial but I would like to state my case. I understand, it's probably a bias against me, but
yeah. So, Mr. Jackson, have you had a chance to talk to an attorney today?
No, but sir. I know I have the right to pro se, and I know I have the right to an attorney, but I would just like to say, what happened last night. And
okay, Mr. Jackson, please.
No, sir.
Please do not.
I would be honored.
I don't want you to incriminate yourself. Right.
No. I would be honored if I could just say this, because it's not like I'm pleading not guilty. All right. I'm trying to say, and I quote, I had to go to the bathroom, and what happened? No, you're on.
So, Mr. Jackson, I'll let you speak. I just want to check in to see first if is there someone from the city of Lacey here covering for court-appointed counsel. I don't see anyone on Zoom. Have you been speaking with any of your public defense counterparts today?
No, Your Honor. For some reason, I was under the impression Mr. Swenson was covering, and I did send an email a couple of hours ago, but I haven't heard anything back.
Okay.
I can shoot him and Miss Kamiri a quick email and see if anyone's there.
Okay. Thank you.
It's just, today's Christmas Eve. Yesterday was the day before Christmas Eve. I got released yesterday, and while being released, my impatience and my ADHD flared up. So when they brought me to the first release spot, I just had to get out the van. I went to Fred Meyer's, walked around Fred Meyer's for a minute, and then after I left Fred Meyer's, I went over to Michael's and Marshall's, walked through Michael's, walked through Marshall's.
Mr. Jackson. All right, I know you want to just say your piece, and at an arraignment, you do have the right to plead guilty, but I strongly advise you, and we're going to try to see where the Lacey public defenders are, but I strongly advise you at least speak with an attorney before deciding to move forward with how you're going to resolve this case, because there may be consequences you're not thinking about right now, and I want you to be fully mindful of those before starting to talk about what happened, okay?
Yes, sir.
So you do have the right to change your plea at an arraignment, but I want to have you talk to a lawyer before you do that, okay?
Yes, sir.
Would you like me to step outside and see if I can reach Mr. Swenson?
That would be wonderful. Okay. Thank you. We're trying to get the Lacey public defenders here to have some. Yeah.
All I'm asking the court, or all I'm asking you, is to just please release me for Christmas and give me a court date outside of jail. That's all I want. I don't want to sit here and do it I want to be free for Christmas. I want to be able to walk around and just enjoy Christmas.
Yeah. So Mr. Jackson, we're muting you here real quick, just because I understand that's what you're asking me, and I don't want you to say anything that's against your interests here. All right, we're going to try to get you an attorney before you address the court. Okay. All right. Good afternoon, Miss. Could you let me know how to pronounce your name? I don't think we've had the pleasure of meeting yet, and I don't want to butcher it.
No worries, Your Honor. Amy Garisco for the record.
All right. Good afternoon, Ms. Garisco. Thank you for being available on such short notice.
All good.
All right. And did you have a chance to speak with Mr. Jackson there?
Yes, Your Honor. I did speak with Mr. Jackson. I explained his rights. I do believe he understands them. We like to waive formal reading. We'd like to stipulate a probable cause for this hearing only. We'd also like to enter a plea of not guilty. At the court that I'm familiar with, they do ask us to fill a screening form to see if the person would qualify for a public defender. I'm unsure if your court does the same thing, Your Honor. But I do think that he would qualify.
Yeah, we generally do. I do note that he was appointed a public defender yesterday for the matter that's on for backup out of the city of Lacey. So I'll go ahead and appoint Pacific Point Defense to represent Mr. Jackson on this new charge as well. So Mr. Jackson, you'll have the same lawyer for all your cases. And the court will enter a plea of not guilty to that charge of criminal trespass in the first degree. Okay. So Mr. Jackson, I know we sort of talked a bit before you had a chance to talk to the lawyer here, but again, we are here for an arraignment on a new charge. This is criminal trespass in the first degree. That's a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine. You had a chance to speak with the attorney there, Ms. Garisco. Next, the court's going to set release conditions, so restrictions on your behavior while the case is pending. And I'm going to start for recommendations on that with the prosecutor here in the courtroom, Miss Eddy.
Yes, Your Honor. The city of Lacey is asking bail be set at $5,000. The defendant was just in front of Your Honor yesterday and promptly went back to the same place where the court told him not to go. I note the factual basis based on the report for his new arrest for the criminal trespass case. It began as a report from the target on Slater Kenny that there was a male subject in the bathroom claiming that he had a gun. Then dispatch received a call from the subject in the bathroom saying he was being held hostage and refusing to provide his name to dispatch. When officers arrived at the scene, they went in the bathroom, they opened the door and they saw there was an airsoft pistol and its magazine lying on the floor by the door. One officer secured the gun. The other officer went inside and contacted the defendant, who was identified as Xavier Jackson. The officer described that Mr. Jackson was in a manic state, saying he was scared. And ultimately he was arrested. Also, I believe found on his person was a glass pipe that commonly used for methamphetamine use. So the city would also request conditions of no violations of law, not to go back to target, no weapons, And the city would also request the court consider requiring a DCR evaluation before release. The city is concerned that Mr. Jackson seems to be indicating some kind of delusional behavior and his disregard of the court's order and his release conditions.
I don't.
So
I
that's
don't
the
get it.
basis for the city's request.
It's so unfair. I can't tell the side of the story. It's so unfair. I can't tell the side of the story and be not guilty.
Mr. Jackson.
All right, so Mr. Jackson, we muted you just to protect your rights. I know you want to say your piece. You will have the opportunity. This is not that hearing. We want to make sure you're not incriminating yourself. Okay. All right, go ahead, Ms. Carisco, for recommended conditions on release.
Thank you, Your Honor. We would ask Mr. Jackson to be released on his personal recognizance. We do understand that he recently did have a case a few days ago. However, from my reading of this, this is a non-capital offense. Mr. Jackson's history is limited in the fact that there's not much warrant history, so he would appear. I had discussed with him the importance of staying away from the area, regardless of the allegations are true or not untrue. So we would ask for him to be released on his personal recognizance, as he would be abiding by staying away from that area. He does not show a substantial danger from talking with him to himself. So we would also ask, or my read is that he doesn't show substantial danger to the public, though there are allegations that could cause concern, but we would ask for him not to be held on DCR either. He does have family in the area that could help him get to court. He lives in the Tacoma area, has expressed that he would be able to get to court on time, follow all court orders. So we'd ask for him to be released on his personal recognizance. If the court is entertaining bail, we would ask for him to be given a nominal bail, considering that he is indigent and qualifies for a public defender. Thank you.
Thank you. Ms. Eddy, can you can you return to the allegations again? And as far as the context of law enforcement being called, I think you mentioned being in a bathroom, reports of not being able to leave, something to that effect.
Yeah, the officers involved, there was a male subject in the bathroom claiming that he had a gun. Ultimately, the officers found an airsoft pistol there, and the defendant, who they described was in a manic state and saying he was scared. I'd note in the report from the case that his other case, if I could get to that, on December 22nd, the concerning part of his conduct in that is that when the officers were trying to stop him in regards to a theft and advised him he's being detained, he starts running towards Golf Club Road. Then they observe him running into Fred Meyer, and as he goes through the door, he's pushing multiple people. As again, they're trying to apprehend him. He continues inside. Witnesses are telling the officers which way he ran and Fred Meyer. Ultimately, when they did detain him, he was yelling and screaming. They tried to Mirandize him. And again, I think he would not stand up on his own and continue to yell and scream when they were trying to read him his Miranda's rights. So the city's also concerned he poses a danger to himself when you evaluate his conduct between those two investigations.
Okay. I thought I heard reference in this case to somebody else being in the bathroom with him, reporting being unable to leave.
That was him.
That was him. Okay.
Yes, they got a second call saying he was. They got a call from the subject in the bathroom saying he was being held hostage, but he refused to give a name.
Oh, okay.
And it doesn't indicate that they located anyone else. It's silent as to whether anyone else was in the bathroom or not.
Got it. Okay, thank you. All right, Mr. Jackson, I'm going to take you off mute because I'm going to ask you a few questions. Okay. Do not talk about what happened yesterday. Okay. All right. Thank you. We able to do that? Okay. All right. I'm sorry, if the folks if the officers there we go. Thank you. All right, Mr. Jackson, Miss Garisco there mentioned you have family in Tacoma. Is that accurate?
No, my cousins, my cousin's mom and his family, they live in the Lacey, Thurston County area.
Where do you live? Where do you live?
I live in Tacoma, Washington.
Okay. All right. If you were to be released today, how would you be able to get back up to Tacoma?
Nisqually provides transportation from Nisqually Jail. Their first stop is Lacey. Their second stop is 512 Park and Ride in Tacoma. I get out in 512 Park and Ride. Even if I was impatient and bouncing off the walls, I do it because I know that it's the best thing for me to do, because now I'm putting myself in jeopardy and putting my word to you if you were to give me PR in jeopardy.
All right. And then up in Tacoma, what's your living situation like?
I stay at the rescue mission, but ironically, funny thing is, my grandfather works for the rescue mission.
Are you enrolled in any kind of counseling or treatment program?
No, but I can be if that is part of your imposed release conditions.
All right, it's not. You have a couple of failure to appear for hearing warrants from this year out of Lakewood and Seattle.
Yes, but I don't have any warrants right now. Right. The one from Lakewood.
No, I know. Yep, I'm more asking about, do you have plans on how you're going to be able to get to court?
Yes, sir.
Our Thurston County does allow folks to appear remotely. Do you have access to, if you're up in Tacoma, do you have access to internet service, a smartphone, things like that? I have a phone,
and we're lucky enough that Inner City Transit provides 2 buses from 512 Park and Ride to Olympia Transit Center.
Okay. All right. Okay. All right. Well, I'll cut to the chase, Mr. Jackson. I'm gonna release you. There's some very good reason to keep you. Definition of not complying with court orders is to get picked up the day after you're released, right back where you were supposed to not be, and that's an allegation, right? You're presumed innocent of that, but those allegations are pretty serious. And I'm looking at some current warrant history, but there's not a lot. And if you are staying at the Union Gospel Mission, I also understand, challenges with making court dates associated with that kind of a situation. So, and if you've got a plan to get back to Tacoma, then that gives me also a bit more assurance that you're not going to go back to the Fred Meyer in this case. And given the nature of the allegations against you, I'm not prepared to make any kind of comments on what you're going through right now, but I don't think keeping you in custody pre-trial is the right call. I'm not saying history here. There's some violent history that's relatively recent that gives me also concern, but given the nature of the allegations here, I think under the rules, personal recognizance release is appropriate. So I'll release you on this, but I'm going to add a bit of an extra layer of supervision. You said you do have a smartphone, is that right?
Yes, sir.
All right, so I'm going to put you on pretrial services supervision. And what that means is there's going to be a phone number on the paperwork you get at the jail. That's pretrial services. And I want you're going to have to call them within 48 hours of your release. And one of the things you need to do is, I'm going to put a note here in your exit paperwork. You need to let them know, pretrial services, you need to let them know where you're staying. All right. I'm not saying you have to be in Tacoma, but I do want pretrial services to know, kind of where you're staying. And so that we're able to sort of get a sense of where you are while the case is pending. Considering the nature of these allegations are, trespassing and going back to somewhere you're not supposed to be. So on the paperwork you're going to get today, there's a phone number for pretrial services supervision. All right, call that number within 48 hours of your release. I don't think they'll be open tomorrow on Christmas. All right, so sometime end of day on Friday, make sure you've called them, okay?
Yes, sir. Thank you, Your Honor.
All right. So then what I'm going to do is I'm not going to make any changes to you were released on the other matter, the theft and obstruction case. It looks like for those, you've got pretrial hearing set for January 26th. I'm going to keep these all together. So your pretrial hearing on this case is also going to be January 26th at 10 a.m. So that's going to be at 10 a.m. Again, you can attend that on Zoom. Okay, so no need to try to figure out how to get back down to Thurston County. But if pretrial services, they're going to get notifications that they need to hear from you by Friday. And if they don't, then they're going to file a violation report, and that can be grounds for a bench warrant. You understand?
Yes, sir. Thank you, Your Honor.
All right. Okay. All right. Well, thank you, Mr. Jackson. You've got Pacific Point Defense to represent you. So you'll have that same public defender on both cases, court dates on both cases. And again, now you're on the only real difference here is you've got pretrial services supervision. Other conditions of your release, I believe are the same as the other case, which is to have no contact with the Fred Meyer. Is that right?
Target, Your Honor. Target is where the thefts were from, and Fred Meyer is just where he was going to get away from the cops.
I see. Okay. But the trespass allegation is from the target?
Yes.
Okay. All right. So have no contact with the target in Lacey and have no criminal law violations. And all right.
Yes, sir, Your Honor. Thank you. Merry Christmas.
All right. Happy holidays and good luck to you, sir.
Calling the matter, City of East Lansing versus Andrew Bishop. This is case number 25430OM. We're here today for what I understand will be a plea. May I please have appearances for the record?
Thank you. May it please the court, Heather Sumner on behalf of the City of East Lansing.
Morning, Your Honor. Melissa Vachon on behalf of Mr. Bishop, who's here from appearing by the Polycom from the jail.
Thank you. And hello, good morning, Mr. Bishop.
Morning, Ms. Greenwald. How are you? Merry Christmas.
You too. I can hear and see you clearly. Can you hear and see me?
Yes, ma'am.
Thank you. I understand we're here for a plea today, and I've received a plea bargain agreement. It informs me that the parties agree that Mr. Bishop will plead guilty to the crime of trespass and that there is a sentencing agreement to time served. Ms. Sumner, is that a true and accurate statement?
Yes.
And Ms. Vachon, is that true and accurate?
Yes, it is, Your Honor. He has
And
been at the jail since November 15th.
Okay, very good. And I have that. It would be 34 days in the Ingham County Jail. Mr. Bishop, is that what you wish to do today?
Yes, ma'am.
Would you please raise your right hand? Mr. Bishop, do you solemnly swear or affirm to tell the truth under penalty of perjury?
Yes, ma'am.
Mr. Bishop, that plea agreement we just discussed on the record, is that your understanding of the plea agreement?
Yes, ma'am.
Has anyone promised you anything else I don't know about?
No, ma'am.
So do you understand you're pleading guilty to a crime known as trespassing?
I understand.
Do you understand that's punishable by up to 90 days in jail and a fine of $500?
I do understand, Your Honor.
And also there is a sentencing agreement that the court would sentence you to time served, which by, I think, the calculation agreed upon would be 34 days time served. Is that your understanding of the sentencing agreement?
Yes, ma'am.
I just need you to know that I'm not a part of that agreement. However, if I don't follow it, you have the right to withdraw your plea. Understood?
Understood.
Mr. Bishop, I have a form here. It's called Advice of Rights. It looks like it was signed for you with permission a couple days ago. Did you and Ms. Vachon have the chance to discuss your Advice of Rights form?
Yes, ma'am.
Do you have any questions about the rights detailed on this form?
I do not.
Do you understand that by pleading guilty today, you're giving up all of these rights?
I do understand.
And so we will not have a trial of any kind. Understood?
Understood.
Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
Has anyone forced you to do this?
No, ma'am.
Is it your own choice?
Yes, ma'am.
Mr. Bishop, are you on probation or parole to any other court?
Not that I know of.
Okay.
I didn't know this now.
I'm asking just because it's possible this could result in a violation. I just need you to know that possible consequence. Understood?
Yes, ma'am.
Likewise, if you're not a U.S. citizen, this plea could impact your immigration status. Do you understand that consequence if it applies?
Yes, ma'am.
Understanding all of your rights and the maximum possible penalty, how do you wish to plead to the charge of trespassing?
Guilty.
Mr. Bishop, back on April 30th of 2025 at approximately 12:54 p.m., were you at a location of East Grand River in the city of East Lansing, Ingham County, Michigan?
Yes, ma'am.
And what building or business is at that location of East Grand River?
It is apartments.
Okay.
And yeah, apartments, right? It's Capitol Villa apartments right there.
Okay, does that sound accurate, Ms. Sumner?
That does sound accurate, Your Honor.
Okay, and that is accurate in my information as well. Mr. Bishop, do you have any legal lawful authorization to be at that location at those apartments?
No, I did not.
And in fact, were you told that you could not be at that location at those apartments by someone who did have authorization?
Yes.
And on that date, on April 30th, were you there in violation of that order that you could not be there?
Yes, ma'am.
Okay. Ms. Sumner, anything further for the factual basis?
No, thank you, Your Honor.
Ms. Vachon?
Nothing further, Your Honor.
Has the court complied with the court rule, Ms. Sumner?
Yes, thank you.
Ms. Vachon?
It has.
So I accept Mr. Bishop's plea. I find that it's understandingly voluntarily made. It's supported by proper factual basis. Given the sentencing agreement here, are the people in the defense ready to proceed to sentencing? Ms. Sumner?
I am, thank you.
And Ms. Vachon?
We are.
Very good. Allocution on behalf of the city, Ms. Sumner.
Your Honor, in reviewing this matter and discussing with defense counsel some of the circumstances surrounding the case and considering the amount of time that that defendant has been in jail, we believe that the agreement to time served is appropriate for this specific matter.
And Ms. Vachon?
Yes, Your Honor, I would ask the court follow the agreement for time served. Mr. Bishop, he takes full responsibility for returning to the apartment complex on this day when he shouldn't have. He was not trying to cause a disturbance or anything like that. He was using the restroom there, but he understands that he should not have been on the property at all, and he will not return to that property, Your Honor. So I'd ask the court follow the agreement.
Okay, thank you very much. And Mr. Bishop, what would you like to tell me before I impose sentence?
You look beautiful as ever, and I hope all of you have a Merry Christmas. Okay. And life is what we make it.
Well, that last sentence I know is true and sincere. So I appreciate that, Mr. Bishop. You know, I just hope, I think given the charge here, given the sentencing agreement, that I'm very inclined to follow it. And, you know, I won't get to know you any further, Mr. Bishop, but I hope whatever circumstances have led you to where you are, you know, today, you know, perhaps there's things that you can do while in jail or just on your own that you be able to turn things around. And that would be my hope. But in any event, I agree with the sentencing agreement. I don't think that the court through probation or any other type of services would be that's not how you're going to change this, Mr. Bishop. So with all those reasons, I've reviewed I have listened to the allocution, and the court will sentence the defendant according to the sentencing agreement. So it's a sentence of this court, Mr. Bishop, you shall serve 34 days in jail with 34 days credit for time served. Your fines and costs are hereby waived because of the time you have served in custody. Mr. Bishop, you have a right to appeal this sentence. And if you wish to appeal, you would file an application for leave to appeal. You would ask for a lawyer to help you with that application by asking for the lawyer in writing to this court within 14 days. Mr. Bishop, do you understand your appellate rights?
I do. Thank you, ma'am.
Okay, very good. And Ms. Sumner, anything further on behalf of the city?
No, thank you.
Ms. Vashon?
No, Your Honor, thank you.
Okay, that's all for this case, and good luck, Mr. Bishop.
Thank you, guys.
Thank you.
And you are all as beautiful as ever. I hope you have a very Merry Christmas. And remember, life is what you make of it. Ladies and gentlemen, this has been the Court Gallery, and I am your Lone Wolf Usul, your curator for these here videos, and your host for this mega extra long Christmas presentation of the Court Gallery. We do this every single night of the week, even on holidays sometimes. So come on by, visit with us. It happens every night, 8 p.m. Central Time. That's 9 p.m. Eastern, for those of you keeping track. And we do this on the weekends, too. We have brunch on Saturdays, 11 a.m. Central. That's noon Eastern, for those of you keeping track. So come on by and hang out with us. This is what we do. We chat about court cases, and I find court cases for us to watch. I'm your humble servant. The cat is my boss. And I want to say thank you very much for choosing to spend your Christmas evening with me and my friends in chat. And thank you very much for hanging out with us all. It's been an amazing night. And most especially, thank you to Charlene, Heidi, Twice Over, and AI Papa for coming out and supporting the stream in the most integral way possible. You're greatly appreciated. Ladies and gentlemen, as I say every night, y'all have a great night. I am your Lone Wolf Usul, and I am out. Y'all have a great night. See you next time. Bueller. Bueller. Bueller.